Welcome back. We will now proceed with the opening statement of the respondent. Mr. Alexandrov, you have the floor.
Thank you very much, Madam President and members of the Tribunal. Good afternoon. We will proceed with our opening argument on behalf of the Republic of Peru. You have received electronically and hard copies of our slides that we intend to show. Just before I start with the introduction, I want to clarify my terminology. I'll be referring to Freeport as Freeport or claimant, and I'll be referring to the Peruvian subsidiary, which on the slide is SMCV Sociedad Minera Cerro Verde. I'll be referring to it simply as Cerro Verde to avoid a mouthful of abbreviations. So here is what this case is about. Cerro Verde tried to game the system. And here you see a very brief chronology. In '96, Cerro Verde submits to MINEM, the Ministry of Energy and Mines, a feasibility study covering the Cerro Verde leaching project to expand the leaching facilities, the leaching project, and applied for a stabilization agreement based on that feasibility study, which we'll refer to as the 1996 feasibility study. In 1998, Cerro Verde enters into a stabilization agreement for the leaching project on the basis of the 96 feasibility study, and we'll refer to that as the 98 stabilization agreement. The 98 stabilization agreement refers explicitly to the leaching project, and the 96 feasibility study, which is again the feasibility study for the leaching project, is an integral part of the agreement. And for many years, until 2004, it was considered uneconomical to build and operate a concentrator. In 2004, Cerro Verde decided to build a new project, the concentrator project, which is different from the leaching project. And you'll see the leaching project, we have references to oxide and secondary sulfide, because that's what is extracted for the purposes of leaching, and it produces cathodes. So when you see those terms, you know we are referring to the leaching project. The concentrator extracts primary sulfate, and it produces concentrate through flotation. So when you see those terms, you know the references are to the concentrator plant. The royalty law was enacted also in 2004, and that required Cerro Verde to pay royalties on the concentrator project. A new stabilization agreement after that would not have given Cerro Verde the benefit of not paying royalties under the royalty law, because it would have stabilized the regime after the royalty law was implemented. And so what Cerro Verde did was they tried to sneak this new concentrator project into the 1998 stabilization agreement, into the regime that was stabilized by the 1998 stabilization agreement, so that those stability benefits applied to the concentrator plant, and they wouldn't pay royalties on the concentrator plant as well. It's very important to point out that Cerro Verde's own conduct shows that it understood very well that the 1998 stabilization agreement did not cover the concentrator plant. And I will go into that in some detail. But for the purposes of this introduction, it's important to point out that Cerro Verde sought assurances in writing from MINEM that the concentrator project would be stabilized under the stabilization agreement, and never, and I emphasize, never received such assurances in writing. Now, Cerro Verde claimed it received oral assurances from MINEM. However, and again, we'll go into some detail into that, claimant did not submit any documents, even internal ones, recording that such alleged assurances were provided. The Peruvian government consistently held the position that the 1998 stabilization agreement covered only the leaching project and not the concentrator plant. And again, I'll go into some detail to show you, to demonstrate to you that this point is very valid, contrary to claimant's arguments. Cerro Verde gambled, and Cerro Verde was caught. All relevant Peruvian authorities, SUNAT, the tax tribunal, the Peruvian judiciary, correctly determined that Cerro Verde owed royalties and taxes for the new concentrator project. SUNAT issued assessments for underpaid taxes and royalties on the concentrator project. Cerro Verde challenged those assessments before the Peruvian administrative agencies and then before the Peruvian judiciary all the way up to the Supreme Court, and Cerro Verde lost. And claimant now seeks to relitigate the issue that was fully and fairly decided by the Peruvian judiciary. So the bottom line is this. This case is a straightforward case of contract interpretation. The key question before you is, did the 1998 stabilization agreement that stabilized the leaching project extend to the concentrator plant? Cerro Verde's new investment, the concentrator plant, was made years after the stabilization agreement was signed. Did it extend to that project? The answer is no. The 1998 stabilization agreement explicitly applied only to the leaching project. That is the investment project outlined in the feasibility study, which is an integral part of the stabilization agreement. And that's what this case is about. Now, in our presentation, we'll address a number of topics. First, we'll focus on the stabilization agreement itself to show you that it covers only the leaching project. Then we'll talk about Peruvian law, which provides that a stabilization agreement covers the specific investment project defined in the feasibility study. So we'll talk about what Peruvian law says. Then we'll talk about the Peruvian courts and their decisions, including the Supreme Court. Courts that decided as a matter of Peruvian law and contract interpretation that the 1998 stabilization agreement covered only the leaching project. We'll talk about, importantly, about Cerro Verde's own conduct, which shows that it understood very well that the 1998 stabilization agreement did not cover the concentrator project. We'll talk about how Peru has been consistent and transparent in its interpretation of the 1998 stabilization agreement. We'll then talk about how Peru has been consistent in its treatment of stabilization agreements of other mining companies. We'll talk about claimants' allegations that the tax tribunal violated Cerro Verde's due process rights, which rests on unsubstantiated conspiracy theories. We will then talk about claimants' allegations that the Peruvian government somehow misled Cerro Verde into participating in the voluntary contribution program, again, wholly unsupported by evidence. We'll then discuss, something is missing, we'll discuss jurisdiction as our topic 9. Then we'll discuss, for some reason, my slides didn't like that section, but you will like it, I'm sure. We'll then discuss as topic 10 that claimants' treaty claims have no merit, and then we'll discuss claimants' damages claims. So this is the roadmap for our submission. Of course, we will not be able to cover everything in our 3.5 hours, so we rest on our written submissions and all the arguments that we have made, whether we have the time to discuss them in this opening statement or not. The slides, for some reason, decided that the jurisdictional argument will be last, but it will not be last. So let me proceed to our first topic, the stabilization agreement, and I will first discuss the feasibility study. As you see on the screen, Cerro Verde applied for a stabilization agreement, and when it applied for the stabilization agreement, it included in the application the feasibility study, and I quote from their application, related to the project that our company is executing and which is intended to expand the production capacity, et cetera, of copper cathodes per year, in a clear reference to the leaching project. And that's the feasibility study that I submitted with their application, and that became an integral part of the 98 stabilization agreement. And let's take a look at the feasibility study. So this is section 1. The feasibility study covers the Cerro Verde leaching project. You remember that they say in the stabilization agreement, and I'll come to that, the reference to the leaching project is just a label. It's meaningless. The application for the stability regime and for entering into a stabilization agreement is based on the feasibility study, which is an integral part of the stabilization agreement, which refers explicitly, it covers the Cerro Verde leaching project and nothing else. The objective of the study is to evaluate the feasibility of producing 105 million pounds per year of cathode copper. Again, leaching. The study is based on test data results and operating experience obtained to date from leaching secondary sulfide ore at Cerro Verde. There is no question that the feasibility study covers the leaching project and nothing else. Now, according to claimant, this is not correct. Claimant says the 1996 feasibility study envisioned conducting another feasibility study to determine the feasibility of building a concentrator. Well, a possible merely envisioned future feasibility study with unknown results cannot be stabilized. That feasibility study that they say was envisioned did not yet exist at the time. In fact, just the opposite. Multiple feasibility studies, and you see the years, 72, 75, 77, 80, 85, 95, 98, concluded that it was, quote unquote, uneconomical to build and operate a concentrator plant, among other reasons because there was no adequate supply of power and water. From 1916 to the 1990s, the Cerro Verde mine primarily extracted oxide ore and had processed it through the leaching facilities. In fact, in 1997, Cerro Verde dismantled its small pilot concentrator, which was built in 1979 as a proof of concept. And so as of 1998, Cerro Verde had no concentrator plant at all. In May 2004, for the first time in decades, a feasibility study concluded that it had become economical to build a concentrator. So in October of 2004, Cerro Verde decides to build a concentrator, which we refer to as the concentrator project. And that is more than 6 years after the 1998 stabilization agreement was signed, and more than 8 years after the 1996 feasibility study. And so the construction of the concentrator plant was not completed until the last quarter of 2006, 8 years after the stabilization agreement was signed. Minem prepared a report. Minem had to approve the feasibility study and prepared a report that would accompany that approval of the feasibility study. And it clearly stated the objective of the study is to evaluate the feasibility of producing 105 million pounds per year of copper cathodes in Cerro Verde's facilities, considering the results of the experimental tests and operating experience with leaching secondary sulfides in Cerro Verde. The report makes clear what is approved, a feasibility study about leaching. Now, then Minem adopts a resolution approving the 1996 feasibility study, and that resolution also shows the government's understanding that the 1996 feasibility study, and in turn the application for a stabilization agreement submitted by Cerro Verde, covered only the leaching project. Just look at the resolution. It says that the Sociedad Minera Cerro Verde has submitted a feasibility study with the objective of production of copper cathodes, and then Article 1 approves the feasibility study submitted by Cerro Verde, and Article 3 decides to submit to the Office of the Vice Minister and Mines the feasibility study that is approved in this resolution in order to sign the tax stability agreement with Cerro Verde. Without this feasibility study, on the basis of the feasibility, they have to sign this tax stabilization agreement, the stabilization agreement. And then the Cerro Verde shall communicate the completion of the execution of the investments committed in the feasibility study. This is important because the completion of the investment is one of the events that triggers the application of the stabilized regime, of the stabilized benefits. And so the completion of those investments committed in the feasibility study is one of the triggers of the application of the stabilized regime. And that's an important point because I told you earlier, the concentrator plant was not envisaged until some 6 years after the stabilization agreement, and it was not construction. Remember, I told you fourth quarter of 2006, 8 years after the stabilization agreement was signed. Here, it's clear. The investments relate to the leaching project, and their completion is what has to trigger, is one of the triggers of the stabilization, of the stabilized regime. So to conclude on the feasibility study, MINEM's report accompanying its approval of the feasibility study, and MINEM's resolution approving the feasibility study, and of course the feasibility study itself, all indicated that the investment project to be stabilized was the expansion of the leaching facilities in order to increase the production of copper cathodes. That's the leaching project and nothing else. Let's look at the 1998 stabilization agreement itself. Here is section 1. And look at the language. It talks about the application requesting that through a contract, the guarantees of the benefits contained in articles so-and-so of the law be granted to it in relation to the investment in its concessions, Cerro Verde 1, 2, and 3, hereinafter the leaching project of Cerro Verde. Now, I'll get into that. They say it's just a label. It's just a label. That means the mining unit, all the concessions. I'll come to that in a moment. Look at section 1.2. It says the owner attached to its application the technical economic feasibility study. The objective of the study, says section 1.3, is to evaluate the feasibility to extend the production capacity of copper cathodes per year, owning from the heap leaching of the copper mineral in the facilities of Cerro Verde. This is not a label because the subsequent provisions refer explicitly to the feasibility study which covers the leaching project. Now, you already saw that. I want to bring your attention to that as well. There is a model stabilization agreement, and you see the excerpt on it on the left-hand side of the screen. That's the boilerplate that then the investor, the company that is seeking, that is applying for a stabilization agreement, fills in. And they say, well, we could have said anything. Ms. Chapuis, and we'll cross-examine her, Ms. Chapuis says, oh, I could have just put in numbers. I mean, if you, their argument is essentially, it doesn't matter how we name it. We could have named it Juan Perez or Jane Doe. It doesn't matter because it covers, well, what does it cover? And that's important to, they cannot make up their minds whether it covers all of their concessions, all of the company, or all of their mining unit. We'll get into that in a moment, but look at what they took out. First of all, they filled in the blank. They could have called this the mining unit of Cerro Verde, right, as they argue now is the case. They could have called it, maybe if they had listened to Mr. Puig, they could have given it numbers, but they could have called it the leaching project and every other and all other future investments in the mine or in the mining unit. They didn't. They called it the leaching project. Equally importantly, they took out the reference to the administrative economic unit, the economic administrative unit. They took that reference out. Now they argue that the 1998 stabilization agreement extends to the whole mining unit. Well, the term mining unit is not defined in the law. They say it's equivalent to economic administrative unit. Well, if it was, and well, again, I'll get into that. If it was, why did they take out the reference to economic administrative unit? It was Cerro Verde that specifically limited the scope of the agreement to the phrase, the leaching project of Cerro Verde. They could have said economic administrative unit. They could have said mining unit. They could have said the whole mine. Everything that we do there, we'll be doing from now on for the next several decades. They could have said anything. And they said the leaching project and took out economic administrative unit. And I'll show you why they did that. So the mining law and the regulations require an application by the mining company to create an economic administrative unit, and then requires a resolution from the Directorate General of Mining of MINEM to approve that application. So, and we've given you on the slide the relevant articles of the law. The point is, you don't just say, I have an economic administrative unit. You have to apply, and it's approved. Well, claimant admits that Cerro Verde did not submit an application for an economic administrative unit. We refer you to their reply. Cerro Verde did not and does not have an economic administrative unit. And that's why they took out that reference. But they argue that this is irrelevant because that they don't have I call it an EAU. They argue that that's irrelevant, but in our submission, this is highly relevant for a number of reasons. First of all, the 1998 Stabilization Agreement cannot apply to Cerro Verde's alleged economic administrative unit if Cerro Verde doesn't have one. This is why Cerro Verde deleted that reference. Two, the fact that they didn't have an EAU demonstrates why they have to invent the term mining unit, which is not in the law, which is not defined in the regulations, and but they have to invent it because they have to call what they have a mining unit in the absence of an economic administrative unit. The fact that they don't have an EAU also demonstrates why claimant and Cerro Verde have been inconsistent in their interpretation of the scope of the stabilization agreement. Sometimes they say it covers the mining unit. Sometimes they say it covers concessions 1, 2, and 3 and the beneficiation concession. Sometimes they say that it covers the mining company or the mining title holder. Well, which one is it? They cannot make up their minds because they don't have an economic administrative unit to be covered by the agreement, and they took that term out. And that's where their attempts to compare themselves with other mining companies that have EAUs fails. Because if SUNAT applied the stabilization agreements of other mining companies that refer to economic administrative units to the economic administrative units, well, that's fine. They have economic administrative units. Cerro Verde doesn't. So what are they inviting SUNAT to apply the stabilization agreement to, or MINEM, to an economic administrative unit that does not exist? Now, they are equating this economic administrative unit to, before that, let me, the claimant said this morning in the opening, and I quote from the transcript, page 7419 to 75.6, now the form contract leaves a blank space in which the investor fills in a referral title for the economic administrative unit that is covered by the agreement. You see it here, a referral title that Cerro Verde chose for its only EAU, which, that title that was chosen was the title Cerro Verde Leaching Project. So council said this morning the Cerro Verde Leaching Project is a title for their one and only economic administrative unit. But again, they don't have one. And they took the words economic administrative unit out. It is also important, and I don't want to interrupt my presentation and show you their slides, but you will see eventually claimant slide 72 when they were talking about Tintaya and the alleged inconsistent treatment. And I refer you to what they have on slide 72, a quote from SUNAT's assessment resolution that says, the calculation of taxes, which includes income tax prepayments payable by the mining title holder, must be made separately for each of the economic administrative units for which it has signed, it meaning Tintaya, for which it has signed a tax stability agreement. This is a quote from claimant slide 72, a quote from a SUNAT resolution that they say, well, look, in the case of Tintaya, they apply the stability regime on the basis of an economic administrative unit. Well, again, maybe, but they don't have an economic administrative unit. And they're saying, well, our mining unit is an economic administrative unit. They didn't apply for one, they didn't get one. Now, to the extent that there is any question who fills in those blanks and who takes text out, it was the investor, it was the company, the mining company that seeks the stabilization agreement. And we have evidence that we have put on the screen, but counsel essentially admitted to that this morning. It was Cerro Verde that filled in the name and that took out the words economic administrative unit. So I think there is no question that it was not done by the government. And by the way, there is no witness presented by claimant who negotiated that stabilization agreement to explain why this was done. Now, they will say the government has not put forward a witness either. It's not our burden to show what is the scope of the stabilization agreement. It's their burden to show it. And they have not offered a witness who can explain why they chose this name and why they took out the words economic administrative unit. But we believe the answer is clear. They don't have an EAU. It's also instructive to look at they have two other stabilization agreements. And in the 94 stabilization agreement, The 94 stabilization agreement talks about we're showing you again, the model and how clause 1 ended up, what words they took out. But what I wanted to show you on the next slide is the difference between the 94, 98, and 2012 stabilization agreement. So look at the 94. They called it the Cerro Verde project. Now, you heard arguments, if we called it again the Cerro Verde project, it would have been repetitive. It's as if the two stabilization agreements cover the same thing. Well, one, it's inconsistent with their argument that these words don't matter. But two, they could have called it something else. They could have called it the Cerro Verde mining project. They could have come up with a name that made it clear that this stabilization agreement, the 98 stabilization agreement, extended beyond the leaching project, and they didn't. The 2012 stabilization agreement talks about the Cerro Verde unit expansion project. Well, why didn't they call the leaching project and future investment projects related to the mine or whatever? They didn't. They did that in 94, they didn't do it in 98. Now, I will go quickly through the other clauses of the stabilization agreement which support Peru's interpretation of clause 1. So, clause 2, the General Director of Mining approved the technico-economic feasibility study, which confirms our point that it is the feasibility study that defines the scope of the investment project and therefore the scope of the stabilization agreement. Clause 3, mining rights. According to what is expressed in clause 1.1, the leaching project of Cerro Verde is circumscribed to the concessions related to Exhibit 1 with the corresponding areas. Exhibit 1, which you can look at, we didn't put it on the screen, it identifies the geographic area of the mining concession and the beneficiation concession. Claimant will tell you, and has told you, this is the only clause you should look at, because it says, in their interpretation, the stability regime applies to concessions 1, 2, and 3. Well, this provision makes it very clear that the leaching project cannot extend beyond the geographic area of these concessions. But it doesn't mean that the stability regime applies to all of the concessions. Look at the verb, it's a restriction, circumscribed. It's not a definition or a statement of inclusion. It doesn't mean that the scope of the 98 stabilization agreement extends to any project within the geographic areas of these concessions. It says the leaching project is circumscribed by those concessions. It does not go outside of the geographic area of those concessions. That's all that it says. Now, another argument they make on the basis of clause 3 is the second paragraph that you see on the screen, that what is provided in the above paragraph does not prevent the owner from incorporating other mining rights to the Cerro Verde leaching project after approval by the General Directorate of Mining. So they say this means we can incorporate the concentrator project into the stabilized regime. Well, look at the text though. The text explicitly refers to incorporating other mining rights to the Cerro Verde leaching project. The concentrator plant is not a mining right incorporated into the Cerro Verde leaching project. Peru's witness, Mr. Tovar, explains that this clause simply provides that Cerro Verde's mining concessions, if they were expanded to include new pits or new land with MINEM's approval, they could then they could extend the processing at the leaching facilities of secondary sulfide ore from this new land, and that would also be stabilized. But it has nothing to do with the concentrator project. And in any event, Cerro Verde never sought any approval for quote-unquote incorporating other mining rights to the Cerro Verde leaching project. We will address their claim that the expansion of the beneficiation concession to cover the concentrator plant somehow included the concentrator plant into the stabilized regime. But they never actually requested incorporating other mining rights into the leaching project pursuant to that clause. The model stabilization agreement also includes a reference to an economic administrative unit in the third clause. And that reference was also deleted by Cerro Verde. So again, if it was a matter of including new mining rights into the economic administrative unit, that would have been a different story. They took that language out. And so clause 3 talks about new mining rights to be included into the leaching project. And so the 1998 stabilization agreement reflects the specific circumstances regarding where the project that is subject to the agreement is located in those three, circumscribed by those three concessions. And clause 3 actually confirms that. And again, it was Cerro Verde that took the words economic administrative unit out of the model agreement. Now, let's keep going. The 1998 stabilization agreement, clause 4, it talks about the investment included in the feasibility study and describes what they are in some detail. Now, their argument is, oh, the only thing, there was a minimum requirement of investment to qualify for a stabilized regime, and all the feasibility study did was make sure that Cerro Verde qualified, that they made the requisite investment. Well, if that were the case, then the feasibility study did not need to be detailed, to explain in detail exactly what work would be done, exactly what would be constructed. And here is clause 4 that explains what the feasibility study actually included, and it's very specific. It describes the works pending execution. Then they can be, it is required, if you see in 4.2, if it's required to make any change, it can be done with respect to the works pending execution, provided that the final object of the investment plan is not affected. So if they wanted to amend anything, they could, within certain conditions, provided that the final object of the investment plan, the feasibility study, is not affected. The final object is the leaching project. So they weren't allowed to build something completely different and introduce it somehow into the scope of the feasibility study and the 1998 stabilization agreement. And here in 4.3, you see the detailed description of the work. And 4.4 also explains what happens with the execution of the investment plan. I mean, clearly, none of that covers the concentrator project. The fifth clause, it talks about the execution of the investment plan. Again, the investment plan that, remember, again, all those references to the investment plan, there was no investment plan at the time to build a concentrator project. Clause 6, the commencement of the production. The date of it defines the date of entry into production which is 90 days of continuous operation of the Cerro Verde leaching project. Again, this, what they say is an irrelevant label, appears throughout the 1998 stabilization agreement, and it talks about the entry into production, which is related to when the leaching project becomes functional, and the date of the commencement of the production is fixed. It has to be communicated to MINEM. Why? Because it's important in terms of triggering the application of the stability regime, as we'll see in a moment. And so what triggers the application of the stability regime, one of the triggers is the completion of the leaching project. Nothing to do with the completion of the concentrator project 8 years later. Seventh clause, it talks specifically, again, about the investment plan under the feasibility study and the conclusion of the project, the conclusion of this project, not any future project, not yet contemplated, let alone concluded. And it talks about amendments or modifications to the investment plan, one, to the existing investment plan, and two, those modifications can be done within 120 days, not 6 or 8 years later. Clause 8. Recall that under clause 6.2, as we just saw, Cerro Verde must inform MINEM about the date of the commencement of production. Thus, the period of stabilization begins after the investment is completed. That is, the investment set out in the stabilization agreement, after the investment is completed. Again, clearly, this is the leaching project, not the concentrator project. Everything in the stabilization agreement is tied to the specific approved and completed investment. And the specific approved and completing investment is the leaching project. So it's not just the label, they call it in section 1.1. Everything is tied to the leaching project in all the clauses of the stabilization agreement. Now, as required, and this is important, as required by clause 6 and 8, Cerro Verde informed MINEM, as you see on the screen their letter, about the commencement of production of the leaching project for purposes of marking the start of the stabilization period. And here is what they say. You see the highlighted text on the screen. We inform you that on March 31, 1998, the project for which the contract was entered has completed the 90th day of continuous operation. And we know the foregoing for purposes of establishing the date of entry into production as set forth in section 6.1. So they say, okay, now we trigger the application of the stability regime. Why? Because the project for which the contract was entered into has completed the 90th day of continuous operation. Can this refer to the concentrator project 8 years later? Of course not. It refers to the leaching project, the project for which the contract was entered into. Now, to the extent that there may be an issue of translation here, and we have that in the footnote, and I'm not going to lecture you on the subtleties of the Spanish language, because at least two members of the tribunal know those nuances way better than I can. But I will point out that the Spanish translation talks about el proyecto a que se contrae el contrato. And we have translated that as the project for which the contract was entered into. You will form your own view of the correctness of the English, but rest on the Spanish, it says the same thing. We're not going to show you in detail clauses 9 and 10 because they're lengthy. Claimant argues that those provisions help its case. They don't. And I want here to make sure there is no confusion, because claimant intentionally or unintentionally has created one. We talk about the scope of the stabilization agreement in terms of what investment project is covered, or what is covered, whether it's the concession, the mining unit, the company, or the individual project. That's one meaning of scope. There is another concept of a scope of the stabilization agreement, and that is what are the benefits. What is the stabilized regime? That's a different concept. And clauses 9 and 10 actually talk about what the benefits are. Clause 9 in particular, it says what is stabilized, what benefits are stabilized, what was the regime that was stabilized at the time. They describe the stability benefits. And they don't mention or refer to the concentrator project. And so we don't see how clauses 9 and 10 help claimant's case at all. And those stability benefits, of course, frozen as of the time of the feasibility study, cannot apply to the concentrator plant. Remember, the feasibility study was prepared in 1996. The concentrator plant was not completed until 10 years later. All right, so to conclude our discussion of the feasibility study and the 1998 stabilization agreement, the terms of the stabilization agreement specifically limit the scope to the project defined in the feasibility study, and that's the leaching project. The stabilization agreement refers to a specific project, the leaching project, intended to process a specific type of ore and produce a specific type of copper and copper products. The agreement does not provide that every investment carried out in Cerro Verde's concessions or so-called mining unit is covered. It doesn't say that. The agreement does not provide that the leaching project also includes the construction of a concentrator plant to process primary sulfides. Nothing in the agreement provides that the stability guarantees would extend beyond the leaching project and cover the concentrator project. And we submit the text of the 1998 stabilization agreement is determinative of the scope of the agreement. Now, our topic number 2, we will discuss Peruvian law and how it applies. And we argue the stabilization agreement's language and the feasibility study, which is an integral part of that agreement, are dispositive. Well, to minimize the importance of the stabilization agreement, claimant's argument is, and we'll come to that, it's not, the stabilization agreement doesn't matter, it's what the law says. So we have to go through the law. I will tell you after I go through the law that all this is irrelevant because the Peruvian courts have already interpreted the law. But before I get there, I will tell you why the law doesn't help claimant and supports Peru's position. So let's start with the law, and then I'll talk about the regulations. On this slide, you just see to remind you of how the law came about. It was various decrees that eventually, in 1992, were included in Supreme Decree 014, which was the so-called single unified text. And Title 9 of the mining law governs the 1998 stabilization agreement. So let's start with the mining law and Article 82. So Article 82 provides that stabilization agreements are available to promote and facilitate financing of specific mining projects. And look at the words mining project. It doesn't talk about mining units, doesn't talk about concessions, doesn't talk about companies, doesn't talk about economic administrative units, specific mining projects. Article 82 also provides that the stability benefits take effect only after the mining company has executed the investment project that was detailed in the investment plan. And this would not be necessary if the stability guarantee is applied to the entire mining company or to the entire so-called mining unit. So their interpretation is not consistent with the text of Article 82. Article 83 provides that in order to be able to apply for a 15-year stabilization agreement, the mining title holder must prepare an investment program, and it provides a minimum. So again, it's tied to an investment program. Article 83 also provides that the stability benefits apply exclusively to the activities of the company in whose favor the investment is made. So, a couple of points on that. The benefits are limited to the mining company in whose favor the investment was made, but they don't extend to all of its investments. It doesn't say shall apply exclusively to all the activities of the mining company in whose favor the investment is made. So we say it doesn't apply beyond that company, but it doesn't mean it applies to everything that that company does. Oh, you say, well, then why is this provision, in particular the word exclusively, necessary? Well, for a number of reasons, and one reason was explained by counsel this morning. Another important reason is the Peruvian government didn't want to apply those benefits to the parent company that may make the investment. It won't enjoy the benefit. In this case, say Phelps Dodge, the predecessor of Freeport. The benefits are not granted to. The benefits are granted to Cerro Verde, the Peruvian company in whose favor the investment is made, exclusively to that company and not to any other company. That does not mean that it covers all the investments made by that company or in favor of that company. And if you have any doubt about that, this is confirmed by Article 84. And this is what Article 84 says. It explains that a stabilization agreement will provide the guarantees, including in the mining law, in relation to each investment project, according to the characteristics of each project. So it's based on an individual project, not company, not mining unit, not concession. Article 85, which you see on the screen, provides that in order to obtain stability benefits, the mining company must submit a technical economic feasibility study which must be approved. Well, again, if this is just to make sure that they cover the minimum investment to qualify, there would be no need to submit a multiple-page feasibility study explaining in great detail exactly what needs to be done, what is planned to be done, what the investment plan or the investment project is. Article 85 also provides that the stability regime is triggered by the approval of the feasibility study as discussed earlier. So just to make sure you understand, the stability regime is frozen at the time of the feasibility study, and then the agreement applies when the investment is completed. None of this can cover the concentrator project. The conclusion under the mining law is the company must submit a feasibility study describing the investment plan for which it is seeking stability benefits. That feasibility study must be approved by MINEM. The applicable laws are stabilized as of the date on which the feasibility study is approved, and once the mining company qualifies for and enters into a stabilization agreement, the stability benefits do not take effect until that project is completed and executed. The project is completed and executed. Again, that cannot refer to any future investment project. And the stability benefits apply exclusively to the activities of the investment project described in the approved feasibility study and for which the investment was made. So, under law, the scope of the stabilization agreement is limited to the specific investment project described in the approved feasibility study and identified in the agreement. Now, according to claimant, the scope of the stabilization agreement is irrelevant. There is a quote from their reply. They say, it's the law. Nothing more and nothing else. So the stabilization agreement and its scope are irrelevant, essentially. It's the law that says to whom the benefits apply and how and when and what scope, etc. If that were true, there would be no need to submit a feasibility study to define the investment project. There would be no need to obtain approval for that investment project, nor even a need for a stabilization agreement to refer to a specific investment project described in the feasibility study. There would be no need for any of that, but that's not the case. This cannot be the case. Claimant argues that all the activities of a particular mining company within its concessions or within a mining unit, quote unquote, are covered by a stabilization agreement, even, as in this case, even if the stabilization agreement refers to a specific investment project. Disregard that, they say. But that cannot be the case because, as we saw, the mining law refers on numerous occasions to specific investment projects described in feasibility studies. So the mining law sets the parameters. And they tried to mock this morning the point that it says the outside boundaries. It says the outside parameters. It says the parameters of who can apply for that benefit, mining title holders, not any type of company, what types of investments can benefit so investments in mining activities, not other investments. Where those investments can be made within concessions, not outside of concessions. What legal regime will be stabilized. Yes, it provides the parameters of what can be done. But the specific investment project that benefits from a specific mining stabilization agreement is defined in that agreement, not in the law. The law cannot identify a specific investment project that a company wants to develop. It's up to the company to say what they want to do. And that's why they take the model stabilization agreement and fill in the blanks. So it is the company, not the mining law, that defines what the stabilization agreement applies to. And that definition is set by cross-referencing, incorporating the feasibility study as required by Article 85 of the mining law. And they want you to ignore, in this case, the feasibility study and say, well, leaching project is just a label. And so the scope of the 1998 stabilization agreement is expressly limited to the specific investment project, one, defined in the agreement, not just in section 1.1 as we saw, but throughout the agreement, described in the 1996 feasibility study, which again is an integral part of the agreement. So we heard again this morning the argument that we really don't understand, which is that in 2014, Peru amended Article 83 by adding Article 83B, and they say, well, this was, they said it narrowed the scope of Article 83, therefore this is an admission that Article 83 was broader. Remember, the initial text of Article 83 is on top. The effect of the contractual benefits shall apply exclusively to the activities of the mining company, and we talked about that. And they said, well, now what they did was narrowed it, which means that it was broader before. Well, it didn't, because look at the text that was added. Provided that the said investments are expressly mentioned in the investment program contained in the feasibility study that is part of the stability agreement, they make their argument on that basis and forget the rest, which is, or the additional activities that are performed after the execution of the investment program, provided that such activities are performed within the same concession where the investment project, that is the subject matter of the agreement entered into with the state, is being developed. So this expands the scope to additional activities. And it did not narrow, it did just the opposite. It expanded it, which shows that it was narrower before. And if you have any doubt, look at the statement of reasons which the executive branch issued explaining the purpose of the amendment. This was an amendment introduced to Congress by the executive branch, and they stated the reasons. And this is what they said. They said, pursuant to the legal framework in force, it would not be possible to stabilize pre-existing assets or investment, nor those investments that did not appear in the feasibility study that is attached to the stabilization agreement. Well, now, with this amendment, you can stabilize additional activities that are carried out after the execution of the investment program. You couldn't do it before. Now you can, after the 2014 amendment. Clearly, this is an expansion of the scope, which clearly shows it was narrower earlier. And we think that's dispositive of this argument. That's the law. Let's talk about the implementing regulations. Article 18. So Article 18 requires certain information to be submitted in writing for companies to take advantage of the stability benefits. And one of those requirements, again, is the feasibility study for the purposes of Article 82 of the single unified text of the mining law, and the investment program with the completion dates in the case of Article 78 of the single unified text. So that's what they have to submit, a feasibility study about the specific project and the investment program. So they tell, oh, nowhere in the law or the regulations there is a reference to project or programs. Well, here is one. A specific investment program is required. And the completion dates are important, and I told you why, because they're one of the triggers of the application of the stability regime. Article 19 imposes very specific requirements on what the feasibility study should prove, thus delineating the investment project that is proposed to be made. You see, and I'm not going to go through it, the requirements of what should be included in the feasibility study. The information to be included in the feasibility study allows the specific investment project for which the study is prepared and which will be stabilized to be entirely identifiable and separable from any other investment project conducted within the same concession. The language of Article 19 puts an end to claimants' unsubstantiated theory that projects, as used in Clause 1.1 of the 1998 Stabilization Agreement, is merely a synonym of concession or a mining unit, because the information included in the feasibility study describes a specific project, an investment project, as indicated in Article 19. The government needs to know not only that the investor has met the minimum requirement for investing to qualify for stability benefits, but exactly what this investment is, what this investment plan is, in great detail. Article 22, which you see on the left-hand side, and you see Article 83 of the mining law on the right-hand side, when Article 22 of the regulations is read together with Article 83, it refers to specific investment pursuant to the investment program approved by the government. And it is, of course, consistent with Article 83 of the mining law, which requires a specific investment program and limits the parameters that govern the stability benefits exclusively to the activity of the mining company. Now, claimant reads the first paragraph of Article 22 as if it refers to all of a title holder's investments in all of its concessions. But it doesn't say that. It says exclusively for the investment that it makes in the concession. Not all the investments and not all the concessions. So when you read it that way, you see it's consistent with Article 83. Claimant also reads the second paragraph of Article 22 in isolation. It says, concessions or economic administrative units shall keep independent accounts and reflect them in separate earning statements. Well, again, you have to read that together with Article 83 of the mining law, which grants stability to investment projects, but you also have to read it together with Articles 24 and 25 of the mining regulations, which I will show you in a moment. So here is what Article 24 says. The Directorate General of Mining shall submit to the Office of the Vice Minister of Mines the record and the Director resolution approving the feasibility study or investment programs, as the case may be, which shall serve as the basis to determine the investments that are the subject matter of the agreement, in order to proceed with signing the original prepared in accordance with the model approved pursuant to Article 86. So it clearly says the feasibility study or investment program which will serve as the basis to determine the investments. Now, again, there is a translation dispute. We've given you our translation and claimant's translation. The members of the tribunal will decide which one is the correct, but you see that claimant has translated the word subject matter in the underlying text as set out, and we believe it's incorrect and misleading because the word in Spanish is materia del contrato, and we've translated that as the subject matter of the contract, which indicates that the feasibility study determines the investments are the matter or the subject matter of the stabilization agreement. And that's, we think, is important. And so it's the feasibility study that is the basis for determining the specific investment that would be stabilized under the stabilization agreement, and that will become the subject matter of the stabilization agreement. And that's what the regulations say. And then finally, Article 25, mining companies are required to have available for the tax authorities documents that demonstrate the application of the stabilized regime to the specific investment projects, new investments or expansions for which the stabilization agreement was approved. So while Article 22, which we showed you earlier, requires separate accounting for separate concessions or economic administrative units, Article 25 explains that separate accounting is required for specific stabilized investment projects, new investments or expansions. If indeed the stabilization agreements automatically applied to the whole concessions or the whole economic administrative units, as claimant asserts, Article 22 would be sufficient, and Article 25 would make no sense, or at best would be superfluous. But it's there, and it requires separate accounting, project by project. And indeed, and that's very important, Cerro Verde was capable of separating the accounts, and in fact did separate the accounts between the leaching project and the concentrator plant. They'll say it was not possible. They did it. According to claimant's witness, Mr. Aquino, Cerro Verde's chief engineer, Cerro Verde separates the accounts, including shared costs, between the leaching project and the concentrator plant. In his witness statement, he gives an example of what he calls a typical, quote-unquote, calculation performed by Cerro Verde. And you see that, contrary to claimant's allegations in this arbitration, separating the accounts between the leaching project, which was the stabilized project, and the concentrator project, which was the non-stabilized project, was not only possible, contrary to their statement, but Cerro Verde actually did it. They calculated separately the costs and the profits of the two projects. You see flotation, which is concentrated, and then leaching. And the calculation, the typical calculation, separates the costs and the profits. Now, there are amendments to Article 22 of the regulations in 2019 to make it consistent with the amendment of the mining law. We showed you the 2014 amendment of Article 83 of the mining law, which expanded in our submission the scope of the mining stabilization agreement to cover new investments. Article 22 was amended simply to reflect in the mining regulations that 2014 amendment to the mining law. That amendment doesn't help claimant's case at all. Article 2 of the mining regulation, claimant relies on that provision, which you see on the screen. It sets out the parameters that govern the application of the stability regime, which cannot extend beyond concessions or units within which there are investments covered by a stabilization agreement. So yes, the stability regime does not extend beyond concessions or units, economic administrative units. But Article 2 does not say that stability benefits extend beyond the stabilization agreement to automatically cover the whole concession or the whole unit. It doesn't say that. And again, this provision must be read together with the mining law because it cannot grant rights beyond what is provided in the mining law itself. And you saw that the mining law limits the stability regime to investment projects or investment plans or investment programs. So the conclusion on Peruvian laws and regulations is that the legal framework that was and is applicable to stabilization agreement, and that was explicitly referenced in the 1998 stabilization agreement, shows that the benefits granted under these agreements, the stabilization agreements, are limited to the specific investment project defined in the feasibility study. The 1998 stabilization agreement covered the investment defined in the feasibility study in the agreement itself, and no question that was the leaching project. And so Peru's interpretation of the 1998 stabilization agreement as being limited to the leaching project is fully consistent with the terms and the logic of the agreement itself, but also with the mining law and the mining regulations. By contrast, claimant wants you to believe that a stabilization agreement that covers a specific investment project based on a specific feasibility study nevertheless extends to all of a company's activities in all of its concessions. Claimant wants you to believe that in 1998, when Cerro Verde entered into a stabilization agreement for its leaching project, Peru agreed to stabilize any and all future investments in Cerro Verde's concessions without Peru knowing anything about what those future investments would be. Claimant wants you to believe that Peru granted as of 1998, stability benefits with respect to all future revenue streams relating to Cerro Verde's concessions without knowing what those revenue streams would be. So they get huge tax benefits based on something that is unknown to Peru, what they'll be doing in the next decades. Claimant's interpretation, we submit, is contrary to Peru's mining law and regulations and contrary to the specific terms of the 1998 Stabilization Agreement. The Peruvian courts. Cerro Verde has litigated the matter regarding the scope of the 1998 Stabilization Agreement all the way to the Peruvian Supreme Court. Cerro Verde had fully availed itself of the opportunity to seek judicial review. And absent a denial of justice claim, we invite this tribunal to respect the Peruvian court's decisions on matters of Peruvian law, and I emphasize on matters of Peruvian law. Cerro Verde has not claimed any denial of justice with respect to the Peruvian court's decisions. And you see on the screen the submission of the United States of America, which says, as a matter of customary international law, international tribunals will defer to domestic courts interpreting matters of domestic law unless there is denial of justice. It is well established that international arbitral tribunals, such as those established by disputing parties under the U.S.-Peru TPA Chapter 10, are not empowered to be supranational court of appeal on a court's application of domestic law. A fortiori, domestic courts performing their ordinary function in the application of domestic law as neutral arbiters of the legal rights of litigants before them are not subject to review by international tribunals absent a denial of justice under customary international law. Were it otherwise, it would be impossible to prevent Chapter 10 tribunals from becoming supranational appellate courts on matters of the application of substantive domestic law, which customary international law does not permit. But this is what claimant is inviting you to do. After SUNAT's claims division and the tax tribunal confirmed the 2006-2007 and then the 2008 royalty assessments, Cerro Verde challenged those assessments and the corresponding tax tribunal resolutions before the Peruvian courts and lost. I will go through first the 2008 royalty assessment and briefly the history. The first instance court, when they challenged that assessment, held in Cerro Verde's favor, annulling the 2008 royalty assessment, and this is the only court decision that has been issued in their favor, but that was overturned. The Superior Court of Lima, which is the appellate court, revoked that decision and held that the scope of the 1998 Stabilization Agreement was limited to the leaching project, and that Cerro Verde had to pay royalties with respect to the concentrator plant, and you see that language on the screen. Cerro Verde challenged that decision of the Superior Court of Lima before the Supreme Court, and the Supreme Court ruled against Cerro Verde, holding again that the 1998 Stabilization Agreement did not cover the concentrator project. And yes, we will show you a few excerpts from those decisions, because the argument we heard this morning is there was never a dispute about a breach of the Stabilization Agreement. What the Peruvian courts are doing here is they are interpreting the scope of the 1998 Stabilization Agreement and Peruvian laws and regulations to come to the conclusion that the 1998 Stabilization Agreement covers only the leaching project and not the concentrator project. And you see here, they talk about Clause 1 of the Stability Agreement, and they say that a systematic interpretation of this agreement based on the content of the feasibility study establishes, based on what the content of the feasibility study establishes and of the investment plan that gave rise to the stability agreement, does not allow to conclude that the primary sulfide plan was part of the Cerro Verde leaching project, since none of the clauses of the stability agreement allude to the investment in general or to the entire mining concession, Cerro Verde 1, 2, 3, as the appellant contends. Clause 1.1 of the Stability Agreement only shows that the application to guarantee the benefits to the appellant was made in relation to the investment in its concession, not in a generic fashion, but rather in terms of what the feasibility study and the investment plan included, which did not specify that the primary sulfide project, which is the concentrator plant, was an infrastructure project of the Cerro Verde leaching project. The Supreme Court rejected Cerro Verde's argument that the clauses invoked by Cerro Verde state otherwise, and say the clauses invoked by Cerro Verde are not suitable for establishing the object of the stability agreement, because clause 3, that's the clause they rely on in this arbitration, and this is what the Supreme Court says. Clause 3 of the stability agreement governs the mining rights that form part of the Cerro Verde leaching project. And it should be noted, the Supreme Court says that the Cerro Verde leaching project is limited to the mining concession Cerro Verde 1, 2, and 3, as well as the beneficiation concession limited to those concessions. But that does not imply that the sulfide plant has been considered within the investment plan of the Cerro Verde leaching project, because neither the feasibility study in the first place nor the investment plan in the second place include the concentrator plant. There is no evidence if the appellant initiated the respective action to include this plant, the concentrator plant, within the investment plan of the Cerro Verde leaching project as stipulated in clause 4.2. So the Supreme Court addressed that argument too. And it said the investment in its concession is any investment that includes the feasibility study and that the investment plan covers. They only extend to the scope of the benefits arising from the stability agreement, which can be interpreted based on the stipulations in clause 1.3, 4.2, and clause 7.2. So the Supreme Court rejected the arguments that they have presented before you in this arbitration and agrees with our interpretation of the stabilization agreement and Peruvian law. And remember their argument that the stabilization agreement doesn't matter. It's what the law says, no more, no less. Well, here is what the Supreme Court said. The purpose of the contractual design is to pursue this functionality of the investment that the investor implements in order to earn the benefits granted to it. Likewise, providing with that identification and understanding that the government is in the right position to supervise and oversee what goods, services, and rights to which it will have to apply the stabilized benefits for the owner of the mining activity. Perhaps the translation is not the most eloquent one, but it makes the point I made earlier. The government needs to know what revenue streams it is stabilizing, what exactly will be done in these concessions, in this unit, or whatever you call it. It's not just anything that we'll do in the future in our concessions or in our mining unit. It's something specific. Which goods, services, and rights will be covered. And here is what the Supreme Court says about clause 10 of this stabilization agreement. It only contains one rule which says limiting the effect of the that the legal regulations will have, which are issued after the approval date of the feasibility study of the Cerro Verde leaching project, but not so for those corresponding to the investment project which gave rise to the sulfur plant, which is the concentrator plant. And again, I showed you Article 25 of the regulations, and the Supreme Court interprets that article as well. And it says Article 25 of the regulations imposes on mining activity owners the duty to maintain at the disposal of the tax authorities the schedules which demonstrate application of the tax systems granted to the expansion of facilities or new investment that contractually enjoy the stability guarantee. This demonstrates the existence of different treatment given to an investment and new investments within the system regarding the guarantees and measures to promote investment in mining activities. A different tax treatment of existing investments and new investments. And we know what the existing investment is, the leaching plant, and the new investment is the concentrator plant. And again, this is, the Supreme Court says the Article 84 of the law introduces the criteria into the configuration of the benefits that will be guaranteed to the mining activities owner as a result of the stability agreement of having to take into account each project's specific characteristics. And this relates only to the activities that are directly related to the investment made, meaning, again, the leaching project. And what we say is that this statement of the Supreme Court is an authoritative interpretation of Articles 83 and 84, which we showed you earlier, and they support Peru's interpretation of those provisions in this arbitration. Here is the Supreme Court's answer to claimant's argument that the feasibility study only serves to make sure that the pre-contractual requirement of a certain amount of investment is met. And the Supreme Court says not so. The feasibility study, it says, and I quote, acts not only as a requirement for signing the agreement, but is also a technical management instrument that is required to assess and measure the investment to be made by the operators of the mining activity. The content of the said feasibility study is a determining factor in evaluating the impact of the legal stability agreement and the operation as a whole of the contractual setup proposed to the state to supply the assurance of stability. So the feasibility study is not just, oh, we've invested the requisite amount, now we qualify. It's a lot more than that. It actually defines what the investment project is. And here on this quote, the Supreme Court, interpreting, as you see on the right-hand side, Article 83, says, into the middle of the quote in paragraph 166, that the legal stability agreement, the Supreme Court finds that the argument supporting the claimant's case, well, Cerro Verde's argument before the Supreme Court, is unfounded, since the scope of the legal stability agreement depends on the type of legal stability agreement that the mining activity owner enacts, and will reside exclusively with the mining company's activities for which the investment has been made. The activities for which the investment has been made. This does not mean that the contractual benefit, the Supreme Court said, will go to any of the mining activities that a mining company performs, but rather solely to the activities resulting from the investment made. That is why the rule introduces the term exclusively in that paragraph. And look at paragraph 167 of the Supreme Court's decision. It confirms that the word exclusively in Article 83 of the mining law means that the activities that benefit from the stabilization agreement are only those related to the investment that is the subject of the agreement, not any activities of the mining company. And the Supreme Court interprets Article 83 of the mining law as extending stability benefits only to the investment described in the feasibility study. Quote, the scope of the contractual benefit extends solely to those activities related to the investment according to what was set forth in the feasibility study. And this makes perfect sense, as we've discussed already. The contractual benefit, the court says, resulting from the stability agreement, the contractual benefits are not as broadly enjoyed as the appellant suggests, which is why it isn't possible to reach the conclusion that the benefit extends to every investment the mining company makes in the concession that is the subject of the stability agreement, but rather only to that investment in the concession related to the Cerro Verde leaching project according to what is established in the technical economic feasibility study. the Supreme Court interprets Clause 7. And again, it says the contractual benefit extends only to the activities for which the mining company made the investment, which are detailed by the feasibility study. And any amendments can be made only within 120 days, not 6 or 8 or 10 years later. Yes, we did go into some detail because the language of the Supreme Court decision is eminently clear and unambiguous. And it interprets the 1998 Stabilization Agreement and Peruvian laws and regulations, and you see how clear and categorical its conclusions are. Let me briefly go over the decision of the Superior Court of Lima on the 2006-2007 royalty assessment. And the history is the first instance court ruled against Cerro Verde. Cerro Verde appealed that decision to the Superior Court of Lima, the appellate court. The Superior Court ruled against Cerro Verde, finding that the 1998 Stabilization Agreement did not cover the concentrator project, and that decision is final. And we'll talk briefly about why it's final. But again, very briefly, the Superior Court of Lima reached exactly the same conclusion, and I will go through this relatively quickly because it is no different in terms of its clarity and in terms of how categorical those conclusions are that support Peru's interpretation of the 1998 Stabilization Agreement and Peruvian laws and regulations in this case. Here is an excerpt that interprets, among others, Clause 1 of the Stabilization Agreement and says, this agreement cannot be made extensive to other investments made subsequently, as is the case of the concentrator plant. Here is the interpretation of Clause 3, which claimant says in this arbitration supports their case. It says that the contractual guarantees established in the Stabilization Agreement apply solely to the investment plan titled Cerro Verde Leaching Project, as well as to any modifications, expansions, corroborated, inserting into that plan as long as it pursues the same objective, but not to other investments. And that the investment subject matter of the agreement is limited to the leaching project. Another excerpt. The petitioner, this is Cerro Verde, failed to prove that the competent authority, which is the General Directorate of Mining, confirmed and included the modifications and or expansions entailed in the new investment plan in the original investment plan titled Cerro Verde Leaching Project in compliance with the provisions of Clause 4 of the agreement of the investment of the 1998 Stabilization Agreement. Consequently, since those investments are obviously different, we're talking about the concentrator plant, in terms of both purpose as well as timing, the administrative stability guarantee granted for the investment plan known as Cerro Verde Leaching Project is not made extensive to the so-called primary sulfides project, which is the concentrator plant. So over and over again, interpreting the various clauses of the Stabilization Agreement and the provisions of Peruvian law, the Superior Court of Lima reaches the same conclusion that we reach here. Right. So this is an important point because remember the argument, and we'll talk more about this argument, that the government Minim approved the extension of the beneficiation concession to cover the concentrator plant, and that approval of the extension of the beneficiation concession somehow extended the benefits of the Stabilization Agreement to the concentrator plant. We'll talk more about that because we'll go over the actual approval and the documents accompanying that approval. But here, the court talks about this argument. They say the investments are obviously different, And both investment plans were executed in the area of Cerro Verde's number 1, 2, and 3 mining concessions of the same owner. And the installation of the concentrator plant and the expansion of the area of the Cerro Verde beneficiation concession were approved by Directorial Resolution number 056. This is not a reason enough to conclude otherwise. So the court looked at the argument that the extension of the beneficiation concession to cover the concentrator plant years after the stabilization agreement was signed somehow extended the stability benefits to the concentrator project. And the court said, yes, there was an approval to extend the beneficiation concession to cover the concentrator plant. That's not reason enough to conclude that the concentrator plant is covered by the benefits of the stabilization agreement and somehow falls within the scope of the 1998 stabilization agreement. So the Supreme Court of Lima defeats the argument that claimant has made then, or Cerro Verde has made then, and that claimant repeats in this arbitration. And again, we'll go over in a moment, we'll go over the approval to see why this is not the case. Again, the Superior Court of Lima says that the contractual benefits shall apply exclusively to the activities of the mining company in whose favor the investment is made. And in this case, this is the Cerro Verde leaching project, because they say, for the avoidance of doubt, Articles 22 and 24 of the regulations and Article 9 of the consolidated uniform and of the uniform text of the general mining law say that the benefit accorded to the guarantees by the guarantees is directed at the investments determined on the basis of the feasibility study. Again, is the feasibility study that is the basis of what is stabilized. So the decision of the Superior Court of Lima is final because Cerro Verde challenged that decision to the before the Supreme Court. During the deliberative process, 3 of the Supreme Court justices agreed with the Superior Court. 2 justices disagreed based on procedural grounds, lack of sufficient reasoning from the appellate court. These justices, the 2 who disagreed, did not opine on the merits, including on whether the 1998 stabilization agreement covered the concentrator project. They did not say that. And you will hear from the experts what is the significance of that deliberation. The Supreme Court was going to deliberate again if Cerro Verde had not withdrawn its appeal. So the Supreme Court was going to continue its deliberations. This was just one stage. But before the Supreme Court could do that, they withdrew their appeal in order to seek to resolve their dispute through international arbitration. And so the decision of the Superior Court of Lima, the appellate court, stands and is the final judgment on the question of the 2006-2007 royalty assessment. It is important, and I alluded to that already, it's important to emphasize that the arguments Cerro Verde advanced before the Peruvian courts are exactly the same as the arguments claimant has advanced in this arbitration. They argued, Cerro Verde argued before the Peruvian courts, including the Supreme Court, just as claimant argues here, that Clause 1, including 1.3 of the 1998 Stabilization Agreement, merely and only describes background facts about the agreement without defining its scope. Literal and contextual interpretations of those clauses 3, 9, and 10 of the Stabilization Agreement that they say support their argument show that the agreement covered the concentrator project. Sunat and the tax tribunal, they argue, misinterpreted clauses 1, 2, 3, 4, 5, 7, and 8 of the Stabilization Agreement. Articles 78, 82, 83, and 86 of the mining law, and Articles 2 and 22 of the mining regulations, they say, provide that mining stabilization agreements grant stability benefits to all investments made within the area of a mining company's concession. And the extension of the beneficiation concession to include the concentrator project, they say, indicated that the 98 stabilization agreement would cover the concentrator plant. These are the exact arguments submitted to you in this arbitration. The Peruvian Supreme Court and the Superior Court of Lima rejected each one of those arguments. So to conclude the discussion on Peruvian law, the Peruvian courts, all the way up to the Supreme Court, have analyzed the terms of the 98 Stabilization Agreement and the applicable mining laws and regulations, and confirmed the proper interpretation of the Stabilization Agreement and the mining law and regulations, which is consistent with the interpretation offered by Peru in this arbitration. The parties agree that Peruvian law governs the scope of the 98 Stabilization Agreement. And applying Peruvian law, the Peruvian courts have held that the Stabilization Agreement applied to the leaching project only and did not apply to the concentrator project. The Peruvian courts held under Peruvian law that stabilization agreements apply exclusively to the investment project for which the agreement was signed, which is described in the feasibility study incorporated into the agreement. And on that basis, the Peruvian courts concluded that Cerro Verde's 98 stabilization agreement did not extend benefits to the concentrator project. And yes, claimant does ask this tribunal to sit as a court of appeal of the final judgments of the Peruvian courts, and asking you, members of the tribunal, to conclude that those judgments, the Peruvian court judgments, are incorrect as a matter of Peruvian law. This is what they are asking you to do. Claimant has made no claim of denial of justice with respect to the proceedings before the Peruvian courts, because they cannot. So they're asking you to conclude that those decisions are wrong as a matter of Peruvian law. Now, I will show you that Cerro Verde's own conduct shows that it knew very well that the 1998 stabilization agreement did not cover the concentrator plant. And first I'll talk about their application for the profit reinvestment program. So, July 3, 2003, Cerro Verde sends a letter to MINEM inquiring whether, even though the concentrator plant is not included in the 98 stabilization agreement, Cerro Verde could reinvest the undistributed profits from the leaching project and invest them into the concentrator project under this profit reinvestment program. So, what is this profit reinvestment program? Provisions of Peruvian law in force in May of '96, when the tax regime applicable to Cerro Verde was stabilized, applicable to the Cerro Verde leaching project, were stabilized, mining companies were entitled to request approval from MINEM to reinvest undistributed profits, free of tax, into new investment projects. And that's what we call the project investment program. So what they were asking was, can we reinvest the undistributed profits from the leaching project into a new project, the concentrator plant, free of tax? That was stabilized under the 1998 stabilization agreement. So they ask, before they apply, they ask. And here is the letter signed by Ms. Torreblanca, their witness in this arbitration. And they ask, here is her testimony in the earlier hearing, the Cerro Verde hearing. You ask for approval even though the new project, the sulfide primary project, that's a concentrate plant, is not confined to the leaching project. That's a quote. And she says, we are saying here, that's the letter, that taking into account that the concentrator was not foreseen originally in the leaching project as a synonym of the production unit, we are asking whether we could include it in the production unit, etc. But focus on the very point. What is tax-free is the undistributed profits of the leaching plant, obviously. The concentrator plant is not is yet to be built. It doesn't generate any profits, let alone taxpayer profit. So that benefit applies to the leaching project, and the question is, can it be reinvested tax-free into a new program? September 8th, Minem responds. Oh, there are two such letters in June. I'll come back to the second one. I'm going over because the letters make it clear by their numbers which letter responds to which. So the letter you see on the screen responds to the letter I showed you earlier. That's a letter from Minem. And in response to this inquiry, whether the undistributed profits from the leaching project can be reinvested tax-free in a new investment program, Minem says that, yes, you can use the stabilized leaching project profits for a new investment program. There is no requirement that this new investment program is stabilized because it's not taxed. It's not an issue of benefits to the new program. The new program at this point in time receives investments. Importantly, allowing the use of such profits from the stabilized leaching project to the new concentrator project does not mean that the new concentrator project is thereby stabilized. And here is the conclusion. They say the project for the primary sulfide exploitation, that's the concentrator plant, could be eligible for this benefit, meaning to receive the tax-free profits from the leaching plant, there being no requirement that the agreement giving rise to the benefit should have previously contemplated it as a project. This new investment project does not need to be contemplated in the 98 stabilization agreement to have reinvested the profits from the leaching project into it, which is logical, of course. They could come up with any new investment program and ask that the profits from the leaching project be reinvested there. But what this text shows is that Minem knows and Cerro Verde knows that the concentrator plant is not included, is not contemplated as a project in the stabilization, in the 98 stabilization agreement. Minem knows it, it communicates that, it's not controversial. Now, this letter is not just a letter. It is a report. It's a legal report. It's a legal opinion. It is prepared by two lawyers, the director of the Technical Regulations Office and the general and a Minem attorney. And you see their names, and the original has their signatures. And then the general director of mining, claimant's witness, Ms. Chapuis, signs this and says, having seen this report and having found it suitable, notify Cerro Verde. So this is not just any letter. It's a legal opinion, legal report prepared by Minem's lawyers and approved by the head of the General Directorate of Mining. Now let's go back. Let's go back to June 8th. They sent another letter. They sent two letters in early June, and they received two responses. I showed you the first letter they sent. The response came in September. In the meantime, they sent the second letter. This is the letter, they meaning Cerro Verde. This is the letter you see on the screen. And what they ask here, among other things, is, well, they say all of the profits that Cerro Verde has deducted for the purpose of the application against the sum invested are actually utilized for the said purpose. All the profits. Okay? And we'll talk in detail about those letters in cross-examination, but here is Minem's response. A second letter, also dated September 8th, but it's a separate response to this particular letter. And because Cerro Verde is asking, are all the profits of the company eligible? This is what Minem's response says. About the question whether the stabilized regime would be applicable to the company, the Prohibition Canadian Article 8 of the Supreme Decree points out that the application of the stabilized regime is granted to the Cerro Verde leaching project and not to the company. And the regime is the one described in the aforementioned agreement. So MINEM, the General Directorate of Mining, is telling Cerro Verde on September 8, 2003, it's not. The stabilized regime is granted to the Cerro Verde leaching project and not to the company. So you cannot use all the profits, undistributed profit, of the company. It's only the leaching project. Why? Because this is the scope of the stabilization agreement. And the stabilized regime applies only to the Cerro Verde leaching project, not to the company. It cannot get more explicit and clearer than that. And again, this is the same type of document. It's a legal opinion, a legal report signed by two lawyers, a MINEM attorney and the director of the Technical Regulatory Office. Then Ms. Chapuis, the General Director of Mining, says, I have reviewed it. The Bureau, meaning her directorate, finds this to be in order, notifies Cerro Verde. So this is not just some sort of a language kind of mistakenly used or not well thought over. This is a legal opinion prepared by lawyers, reviewed by the Bureau, the General Directorate, found suitable or found in order by Ms. Chapuis, and sent to Cerro Verde. And again, I'm going back the slide. Look again at what this language says. The stabilized regime is granted to the Cerro Verde leaching project and not to the company. They say they had no idea. So after they inquire twice in writing whether this profit reinvestment program applies, and they are told, yes, it applies to the leaching project, not to the company, they actually make an application, because that's what the procedure requires. In January of 2004, Cerro Verde formally applies to obtain approval to reinvest the undistributed profits from the leaching project into the concentrator project. And in December of 2004, MINEM issues a resolution approving this request. Let's look at that resolution, because it specifically states, one, that the 1998 stabilization agreement was entered into in relation to the Cerro Verde leaching project, and two, that the new investment program is approved in relation to the profits that must be, and I quote, must be exclusively generated by the Cerro Verde leaching project. In other words, only the profits from the leaching project are stabilized. Again, fine, you can reinvest those undistributed profits, but those undistributed profits must be exclusively generated by the Cerro Verde leaching project. Consistent with the letter of 8 September 2003 that I showed you. Now, what claimant seems to argue is that the approval to use the undistributed profits to be reinvested in the concentrator plant means that the concentrator plant is stabilized. But this shows exactly the opposite. Only the profits from the leaching project are stabilized and can be used for reinvestment purposes. And again, couldn't be clearer, but you also have the September 8, 2003 letter. So on two occasions, one in a formal response to a written inquiry, and two in the formal approval of the investment program, MINEM tells Cerro Verde it's only the profits generated by the leaching project and not by the company. Okay. Now, Cerro Verde sought written assurances that the concentrator plant was covered and never got those. And that is undisputed. Claimant alleges that Ms. Chapuis, MINEM's Director General of Mining, stated orally to Cerro Verde that the concentrator plant would be covered by the 1998 stabilization agreement if the project were to be included in the beneficiation concession.
Excuse me, Mr. Alexandrov, I just got note from Marisa that you have used now 50% of your time and 1 hour and 45 minutes, and she asked whether it would be a good time for a break. But as you like, please go ahead.
I will break immediately. Thank you very much.
Then we have a 15-minute break and then we continue. everyone ready? Then please, Mr. Alexandrov, proceed.
Thank you very much, Madam President and members of the Tribunal. So, where we stopped before the break was, I was saying that claimant alleges that Ms. Chapuis, the then Director General of Mining, stated orally that the concentrator project would be covered by 1998 Stabilization Agreement. And you have the evidence just as an example of Mr. Davenport. I have a few points to make on that. And the first one is, claimant did not submit any documents recording internally this alleged oral assurance that Cerro Verde purportedly received. I mean, again, remember, we're talking about an $850 million investment. Financial consequences of hundreds of millions of dollars. Look at their damages claim, whether they will pay royalties or not. They say they were looking for written assurances. They didn't get them. They say we received oral assurances, and there is not a single internal document that records those assurances. No notes, no memoranda, no emails. Now, Ms. Torreblanca testified in the Cerro Verde hearing that she sent one email, but she could not find that email. One email presumably reporting the conversation with Ms. Chapuis, who allegedly gave oral assurance. She could not find that email because Cerro Verde, she said, had a 10-year retention policy. Well, first of all, it's hard to believe that only one email was the document that recorded this point of crucial importance for claimant and for Cerro Verde. Second, that email was never kept, never retained. And Ms. Torreblanca says Cerro Verde had a 10-year retention policy. Well, Mr. Davenport, her boss, the then president and general manager of Cerro Verde, stated under oath that Cerro Verde had no document retention policy. So either Ms. Torreblanca did not report to Mr. Davenport or anybody, or anybody of her superiors about this alleged oral assurances received from Ms. Chapuis or from Minem in 2004, because she had nothing to report, or there is something but claimant didn't produce it in violation of their document production obligations, withheld documents that were ordered to produce. In any way, we have nothing that records oral assurances given by Ms. Chapuis. What we have is the exact opposite, and I will walk you through a few documents. So you saw already that in September of 2003, Minem told Cerro Verde only the leaching project and not the company is covered by the stability regime. Now, look at July 8, 2004, a presentation to Minem by Cerro Verde. Cerro Verde is asking for an addendum to the 1998 Stabilization Agreement to include the concentrator project. Cerro Verde requires the certainty that only a stability agreement is able to give it, and the requested addendum provides for that certainty. So what does this show? They make a presentation to them. They know that the concentrator project is not covered. They want an addendum to the stabilization agreement to get it covered. August 2004, another presentation to Minem by Cerro Verde. Again, they ask for an addendum to the 1998 Stabilization Agreement to include the concentrator project because they know it's not included. Claimant's witnesses, Mr. Davenport and Ms. Torreblanca, were present at that presentation. And what is Cerro Verde requesting? You see, I'm quoting from the presentation on the screen, inclusion in Annex 1 of the 1998 Stabilization Agreement currently in force by means of an addendum of the primary sulfides concentrator. So they want an addendum to the 1998 Stabilization Agreement so that they can incorporate the concentrator project into the then stabilized regime by including an addendum. Clearly they know the stabilization agreement doesn't cover the concentrator plant. Why otherwise would they ask for an addendum? So they don't even seek written assurances here that it's covered. They say we want to extend the scope of the 98 stabilization agreement by negotiating an addendum that covers the concentrator project. So in the same August 2004 presentation to MINEM, Cerro Verde quotes a SUNAT 2002 report, and you see on the left the presentation and a reference to this SUNAT 2002 report, which means they know about this 2002 report. And what does that 2002 report says? It says the tax stability contracts entered into pursuant to the mining law only stabilize the applicable tax regime with respect to the investment activities that are the subject matter of the agreement. So they know, and this goes to the so-called vote fast later on, they know about the SUNAT report that is dated 2002, SUNAT's view. As early as 2002, SUNAT says that the stabilization agreement apply only to the investment activities, not to the concessions, not to the mining units, but the investment activities, subject matter of the agreement. Now, I want you to focus on this point. In 2003, in relation to the reinvestment program, before applying to get the benefit, to obtain the benefit of that reinvestment program, Cerro Verde asks twice in writing for a legal opinion, are we eligible? They get a response, yes, you are eligible, the leaching project, not the company, is eligible, then they apply. Contrast that, please, with their conduct here in 2004. They go, they say, oh, Ms. Chapuis told us there is no reason to ask for written assurances because you're covered, no worries. Why don't they do what they did in 2003? Why didn't they ask in writing? Is the concentrator plant covered? And they would have received a legal opinion signed by Ms. Chapuis, yes or no. But they didn't ask. In the context of the reinvestment program, they ask twice in writing, they get twice a legal opinion that tells them the leaching project is covered, the company is not. Here they go, meet with Ms. Chapuis. She allegedly gives oral assurances. She tells them no need to ask in writing, and they don't. A big contrast between their conduct in 2003 and now. And again, want to remind everybody, we're talking about an $850 million investment and potential royalties. Look at their damages claim, how important this is for them. And they never submit an inquiry in writing to get a legal opinion from MINEM in writing like they did with respect to the profit reinvestment program. Now, their witnesses cannot get their story straight. So if you look at the slide, Ms. Torreblanca says Cerro Verde understood from the start that the stabilization agreement applied to the concentrator project. Of course, that's not true because they requested to modify the agreement by an addendum, as we showed you earlier. She also says Ms. Chapuis informed Cerro Verde that, quote unquote, it was not necessary to obtain written assurances that the agreement applied to the concentrator. And they are happy with that. It's not necessary. Mr. Davenport testifies that Cerro Verde actively sought to obtain written assurances, but he could not get any such written assurances because the minister was not willing to sign a letter confirming that the concentrator would be stabilized once bit. So Mr. Davenport says something different. We wanted written assurance, but we knew we couldn't get them because that's the way it works in Peru. Ms. Chapuis testified that MINEM never provided Cerro Verde with written assurances that the 98 stabilization agreement applied to the concentrator because, she says, Cerro Verde never submitted a request in writing. Or had they submitted a request in writing, she would have had to go through the same procedure, a legal opinion that she would then review and sign. So MINEM did not informed Cerro Verde that they didn't need written assurances, contrary to Mr. Blanca's testimony, that Ms. Chapuis said it was not necessary. Ms. Chapuis says they didn't ask. Notably, Ms. Chapuis was asked at the Cerro Verde hearing, and I quote, "You say, I confirmed to Mr. Blanca and Mr. Davenport that Cerro Verde did not need a separate written assurances. Did you tell them that or not?" And Ms. Chapuis testified that her response was, quote, "No, they asked whether they could send a letter, and I said, I think not," close quote. So this response is telling because Ms. Chapuis knew that if Cerro Verde did submit a request for written assurances in writing, she would be obligated to respond in writing with a legal opinion. And she also knew that she could not respond in writing to provide the written assurances because she knew it would be inconsistent with the text of the stabilization agreement and the mining laws and regulations. Why not otherwise just tell them, write a letter and I will give you a legal opinion? She said, "No, I think not." "Could we send you a letter?" "No." There are many inconsistencies in the witness testimony of claimants' witnesses. They cannot get their story straight regarding the number of meetings. Mr. Blanca says several meetings, Mr. Davenport says several conversations, Ms. Chapuis says one meeting where she allegedly gave those oral assurances. They cannot get their story straight on the timing of the meetings. Mr. Blanca says before and after June. Ms. Chapuis says that she gave the alleged oral assurances only after she had a meeting with her own team on June 15. The circumstances, of course, are also they cannot get their story straight. The circumstances under which they received the so-called oral assurances. Mr. Blanca says, "We received the oral assurance in a meeting with Minem, quote, after the presentation," close quote, that was given by Cerro Verde. She was referring to the PowerPoint presentation in August of 2004 that I showed you on the screen. Ms. Chapuis says she gave the alleged oral assurances in her room where, quote, there was no possibility of showing a PowerPoint. So they cannot get their story straight. But the more important part is going back to what they asked in those presentations. They asked for an addendum to the stabilization agreement to get the concentrator plant covered. And here you see an internal document confirming that. There is a presentation that contains updates regarding the concentrator project to Phelps Dodge's board of directors. We see the email on the left to which that presentation is attached. And you see in the presentation on the left-hand side, action, modify stability agreement, third quarter of 2004. An internal presentation to Phelps Dodge's board of directors includes as an action item, modify the stability agreement, third quarter 2004. Clearly, Phelps Dodge and its board understood that the 98 stabilization agreement did not cover the concentrator project, because if it did cover it, why would we want to modify the stabilization agreement? But that was the action item there. Now, remember the argument we discussed, their argument, claimant's argument that Cerro Verde requested the Minem's approval to expand the beneficiation concession to include the concentrator project. And they say, this is what Ms. Chapuis told us is sufficient. We'll extend the beneficiation concession to cover the concentrator plant. And by doing that, by obtaining that approval, somehow the concentrator project will be included into the scope of the 98 stabilization agreement. And you remember I showed you that the court rejected that argument, said no, this did not mean that the scope of the stabilization agreement was expanded. Well, here is Cerro Verde's request for MINEM's approval to include the concentrator project in the beneficiation concession. And it does not mention or refer to the 1998 stabilization agreement at all. We're just showing you the document, but you can read it, all of it, and you will find no reference to the 1998 stabilization agreement. Here is the chronology of what happened. MINEM then publishes a notice of that request to extend the geographic area and the production capacity of the beneficiation concession in El Peruano. MINEM approves the request to build a concentrator plant, approves the request to expand the beneficiation concession, and then once the construction is completed, MINEM issues a formal resolution that approves the expansion of the beneficiation concession to include the concentrator project. None of these documents regarding the expansion of the beneficiation concession, none of these documents refers to the 1998 stabilization agreement at all. So this maneuver to expand the scope, somehow to expand the scope of the 1998 stabilization agreement to cover the concentrator plant by means of expanding the beneficiation concession did not succeed. Nothing in the application, the various MINEM approvals and the resolution says anything about the 1998 stabilization agreement or its scope. Another document that shows Phelps Dodge knew that the concentrator project was not covered by the 1998 stabilization agreement. In a 10-K form before the Securities and Exchange Commission, they say, however, it's not clear what, if any, effect the new royalty law will have on the operations at Cerro Verde. They say it's not clear. They don't say, oh, we are covered. We received assurances from MINEM. No worries, we're not going to pay royalties. This statement was made before claimant Freeport acquired the shares in Cerro Verde, but after MINEM had approved the expansion of the beneficiation concession. So if indeed they believed at the time that the expansion of the beneficiation concession somehow expanded the scope of the stabilization agreement, well, their Form 10-K doesn't reflect that certainty. It reflects uncertainty. And then the following year, they repeat the same statement. Well, Council told you this morning that this uncertainty reflected in the 10-K forms was uncertainty that was generated by the political pressure at the time in Peru, not because the legal instruments were somehow insufficient, not because the 98 stabilization agreement didn't cover the concentrator plant, but the uncertainty was created by the political pressure. Well, first of all, this is not in the 10-K form. Second, Council was testifying this morning. They have no witness who prepared that 10-K form to explain that, oh no, this was not because we had any doubt about the scope of the 98 stabilization agreement. This was because there was political pressure in Peru and we wanted more certainty. That's not what the form says, and there is no witness to say that. And Council is testifying, which you should ignore. The lenders for the Cerro Verde's concentrator plant also knew that there was a significant risk that the 98 stabilization agreement did not cover the concentrator plant, and they included that in the text of the master participation agreement, that is the lending agreement for the concentrator plant. They included it. You see the language. They said this would not, if it happens, it's not a force majeure. They knew the risk. The record is clear that claimant never conducted any adequate due diligence to see whether the concentrator plant was covered. We asked in document production for proof of due diligence. However, claimant repeatedly failed to submit any documents that prove that it performed adequate due diligence. Claimants failed to produce the following requested documents that you see on the screen: any communications between Cerro Verde and its lenders who are parties to this master participation agreement that we showed you earlier. Written assurances from the Peruvian government that claimant allegedly requested because they never received them. Contemporaneous documentation of the oral assurances from the Peruvian government that claimant allegedly received. I talked to you about that. Mr. Blanca says, I sent one email about the oral assurances that is never to be found because of a retention policy that did not exist. Nothing. Now, these documents could presumably help to support claimant's argument that it performed adequate due diligence, but claimant failed to submit them. So either they don't exist, in which case claimant did not perform due diligence about the scope of the 98 stabilization agreement, or if they exist, they don't help claimant. Now, claimant says this is irrelevant. Due diligence here is irrelevant because they say due diligence cannot take away rights from Cerro Verde. If Cerro Verde had rights under the 98 stabilization agreement, whether or not we perform due diligence is not relevant. We retain those rights. But it is very relevant that they did not perform due diligence for at least a number of reasons. One, due diligence would have revealed that Cerro Verde and Felsdorf knew all along that the government always held the position that the 98 stabilization agreement did not extend beyond the leaching project. The failure to provide documents is telling because it is not credible. We submit that no documented due diligence on whether the concentrator project was covered exists. Not even one email. The tribunal has to assume that if any due diligence was conducted, it yielded a result not favorable to claimant, which is why claimant has not submitted any documents. And the record clearly demonstrates that claimant and Cerro Verde could not have legitimately expected that the concentrator plant was covered under the 1998 stabilization agreement. In fact, they knew it wasn't covered. As I showed you, they were asking for an amendment to the stabilization agreement. And so claimant can only blame itself for basing its decision to invest $850 million in the concentrator project without any assurances that the project would be covered under the 1998 stabilization agreement. But now claimant wants Peru to pay for that. Now, recall that the Minem letter signed by Mr. Puis of September 8, 2003 that I showed you earlier, where Minem stated explicitly that the stability benefits under the 98 stabilization agreement apply to the Cerro Verde leaching project and not the company. What happens next? In June of 2004, Mr. Puis sends an email to some of her colleagues. The subject of the email is meeting with Cerro Verde, new SA, meaning new stabilization agreement. She says, can you come to my office on the 15th of June 2004? Matter, request for inclusion of the sulfide project in the stabilization agreement of Cerro Verde. Is that legal? She asks her lawyers and others, is that legal? What does this email show? First, she knows, Mr. Puis knows, that the concentrator project is not covered by the 1998 stabilization agreement because if it were covered, there would be no need to include the concentrator project in the agreement. But that's what Cerro Verde is requesting. Mr. Puis was right to question whether it was legal to include the concentrator project in the stabilization agreement because including it would not be consistent with the terms of the agreement and the applicable mining law. And so please focus on this email because at the exact moment when claimant says it received oral assurances from Mr. Puis that the 98 stabilization agreement covers the concentrator project, Ms. Puis herself is questioning whether it is legal to expand the scope of the 98 stabilization agreement to cover the concentrator project. Well, it wasn't legal. Cerro Verde asked for a modification of the stabilization agreement, and Minem did not agree to amend the stabilization agreement. our next topic. So you saw they knew what the situation was with the scope of the stabilization agreement. My next topic is Peru has always been consistent and transparent in its interpretation of the stabilization agreement. So we have set out in our rejoinder, Table 1 at paragraph 305, a series of documents showing that SUNAT, MINEM, the Ministry of Economy and Finance were consistent and transparent in their interpretation of the scope of the stabilization agreements, including Cerro Verde stabilization agreement. And we refer you to that for a full discussion of those documents. Peruvian government agencies consistently interpreted the stabilization agreement as applying only to the specific investment project defined in the agreement and in the incorporated feasibility study, and consistently interpreted the 1998 stabilization agreement as applying only to the leaching project and not the concentrator project. So I don't propose to go over all the documents in Table 1, but I do want to go over some of those. So remember I put on the screen the SUNAT 2002 report. They knew about it because they referred to it in their August 2004 presentation. And this SUNAT report, which, by the way, was public on SUNAT's website, concludes tax stability entered into pursuant to the mining law only stabilize the applicable tax regime with respect to the investment activities that are the subject matter of the agreement. This is the MINEM's letter in response to their inquiry, where they said, you already saw that, the application of the stabilized regime is granted only to the leaching project and not to the company. So in September of 2003, they had that. But there is more. In March of 2004, Minister Polo makes a presentation at the 2004 Mining Royalties Forum. And here is what he says. A company can have stabilization agreement for one project and not have it for another, or have an old activity and a new activity. An investment grants the right to stabilization to that investment for that development and not for the whole company. Again, it's very clear. A company, Vice Minister Polo says, can have stabilization agreement for one project and not have it for another. He makes that presentation at the Mining Royalties Forum. Now, they say, oh, we had no idea. We didn't know. I mean, if you listen to them, and I'll go later on to statements made by MINEM and MINEM officials, and the Minister and the Vice Minister of Energy and Mines to the Congressional Committee on Mine and Energy. Those are all public statements. So they say, claimant says, a couple of things. First, they say, all this, we didn't know until this vote fast I'll come to in 2006. We don't know anything about the government's interpretation. We always thought the stabilization agreement extended to the concentrator plant. We always thought they make it sound as if this is, you know, in the back room of the bar, a dark room where people with cigars somehow, what was the word they used, devised this new interpretation. Well, one, it is not credible to say there was a mining forum. We did not know what Vice Minister Polo said. They're considering an $850 million investment. They don't follow the mining forum. They don't follow the congressional debate where the Minister and Vice Minister of Energy and Mines appear to make statements about the scope of the stabilization agreement, about the scope of their stabilization agreement. They don't follow that. Okay, fine. Even though some of those congressional debates that I'll show you were televised, they don't follow that. They have no legal obligation. Well, okay, but those are public statements. The minister, the Vice Minister Polo did not make that statement in the dark back room of the bar in the middle of cigar smoke. He made that statement to the mining forum. Other statements that I'll show you in a moment were made before the congressional committee. Those were public statements. To say that MINEM is making public statements and they interpret those statements, they characterize those statements as secret policy under political pressure to devise some new interpretation is untenable. a Minem resolution approving Cerro Verde's request for the profit reinvestment program. I showed you that resolution already, December 2004. Again, consistent with Peru's interpretation of the stabilization agreement and the law. The funding must come with the returned earnings, which must be exclusively generated by the leaching project. And again, they say we were inconsistent. The meeting with Phelps Dodge in March of 2005 with Mr. Harry Conger. And Mr. Tovar explains that he was told explicitly that the leaching project was covered, but the concentrator project would not be. And you heard, well, this couldn't be because Mr. Conger made a presentation, this could not have happened. Well, we have a witness who says it happened. Where is Mr. Conger to dispute that? Why is it not here to say, no, this didn't happen? He told me something different. Here is a Minem report of April 14, 2005. In a report, the legal director of Minem to the Minister of Energy, Mr. Isasi, a witness in this arbitration, analyzed the question whether mining companies with mining stabilization agreements in force at the time the mining law was enacted would be subject to paying royalties. And Minem concluded that because mining stabilization agreements grant administrative stability in addition to tax stability, the mining companies with stabilization agreement in force would be protected. But they would be protected only with respect to the investment project referred to in their respective stabilization agreements. Here is that report of April 14, 2005. Claimant alleges that this report supports its position. Now, what claimant has done repeatedly in their written submissions, and in fact this morning in their presentation, is they read the report and they stop before the end. They read the report and they read the highlighted text, and they omit the last sentence. Therefore, only the mining projects referred to in these agreements will be excluded from the royalty calculation basis. Only the mining projects, not concessions, not units, not companies, the mining projects. This is what Mr. Isai said. They never quote that sentence. They stop before that. And they say, oh, this report helps us. It's not clear how it helps us even without that sentence, but that sentence is abundantly clear. And they keep doing that, ignoring that last sentence. And in fact, Mr. Isasi will appear before you. When he appeared in the Cerro Verde hearing, he was, and this is nothing short of scandalous, he was interrupted when he was reading from his report before he could get to that sentence. So again, they are very worried about that sentence, and they want to present to you the document as if that sentence wasn't there, but it is. Here is a draft press release of April 2005 by Minem. It was prepared by Mr. Polo, the Vice Minister of Mines, and it says, again, the mining share title holders who have signed the aforementioned contracts have all the guarantees that the state has granted to the investments that are the subject matter of said contract. So claimant says, well, but it's not clear whether that press release was ever issued. Well, whether or not it was issued, it reflects the Peruvian government's contemporaneous position of what stability guarantees covered. Only investments that are subject matter of the stabilization agreement, nothing more. Now, here you see several documents that I alluded to earlier, presentations by Minem before the Energy and Mine Congressional Committee. Again, public, televised. So to say that Minem was somehow concealing from Cerro Verde its interpretation of Peruvian law and the stabilization agreement when Minem was making public statements in Congress about its interpretation is untenable. On June 8, the Minister of Energy, Mr. Sanchez, and Mr. Isasi, our witness and the general director, the legal director, made a presentation before the committee. And Minister Sanchez explained that mining companies with stabilization agreements would not pay royalties with respect to their quote-unquote stabilized project. Here is what he says. Then who pays royalties? All mining title holders pay royalties, but not for all projects. The mining title holders that before the mining royalty were entered into law contracts with administrative stability will exclude from the royalty calculation basis the value of concentrates or equivalents derived from the stabilized project. I mean, again, it couldn't be clearer than that. And then the advisor, which is Mr. Isasi, says, when determining how much it must pay, the tax administration has to determine what is the reference basis, and to determine the reference basis, it must determine which are the stabilized mining projects and which are the non-stabilized projects. The non-stabilized mining projects pay royalties, the stabilized projects do not pay royalties. I mean, how could it be any clearer than that? A public statement before a congressional committee. Again, the same congressional committee meeting. The minister's presentation also stated that the contrato ley, that is the mining stabilization agreement, would protect, quote unquote, the investment set out in the contract against the new obligation to pay royalties. And again, the presentation included that same language. So who pays royalties? All mining title holders pay, but not for all their projects. Again, I'm saying it for the nth time, but it couldn't be clearer. It's on a project-by-project basis, not company by company, not concession by concession, not unit by unit. Here it is, a public statement before a congressional committee. And again, they make it sound like this was some sort of a black box. It wasn't. Minem prepared a report in response to Congressman Ore's request to provide information about the Cerro Verde Stabilization Agreement. And they say, the report says, the 98 Stabilization Agreement was limited to the Cerro Verde leaching project. You see that on the screen. It refers to the feasibility study, this letter, and says the feasibility study is about the leaching project, and it's the leaching project that is stabilized and nothing else. Now they say, well, this is under pressure from Congressman Ore. Well, focus on those things. Minem or the Peruvian government never, to use the language of claimants, caved in to the pressure to say the leaching project or other projects specifically described in the stabilization agreement should pay royalties. They never caved in. They maintained always that the project that is covered by the stabilization agreement does not pay royalties. Now they say, oh, they caved in under pressure. I just showed you consistent interpretation from 2002 by Sunat and then Minem said you pay royalties for those projects that are not stabilized. You don't pay royalties for projects that were stabilized. Political pressure or not, this was the consistent position. So a letter, again, in the letter, in the October 3 letter to Congressman Ore, again, October 3, 2005, specifically about the Cerro Verde leaching project, they say, the leaching project is covered. It doesn't pay royalties. Unlike the leaching project that is covered by the agreement, the primary sulfide project, the concentrator plant project, will not enjoy the tax, exchange rate, and administrative stability regime. Claimant says they caved under pressure. They didn't cave under pressure. They maintained their position that what is stabilized doesn't pay royalties, but what was not stabilized does pay royalties. A similar letter to Congressman Diaz-Canseco, which says the same thing. The leaching project does not pay royalties because it's covered by the stabilization agreement. The primary sulfide project, which is the concentrator plant, does not enjoy protection under any guarantee or stability agreement. So yes, it pays royalties. Another session of the Energy and Mines Congressional Committee, May of 2006, again, public. Whether they knew about it or they didn't, again, we think it's not credible to say we had no idea what was going on, given that there are people at Cerro Verde whose job is to follow what's going on. Regardless, these are public statements. And Mr. Isasi makes a presentation to the Congressional Committee on Energy and Mines and explains that the 98 Stabilization Agreement only covered the leaching project and not the concentrator project, because it was only the leaching project that was delineated in the 1996 feasibility study. And again, you have excerpts from the presentation that could not be clearer. Stability, it says, is given to the investment project clearly delineated by the feasibility study and agreed upon in the contract. It's not granted to the company generally or to the concession. The primary sulfide project on the right-hand side, you see part of the presentation. The primary sulfide project, that is the concentrator plant, was not provided for within the leaching project. There was no request to incorporate it into the leaching project. It is therefore not part of the stabilized project under the agreement. Accordingly, any profits generated by the sulfide project, the concentrator project, may not be reinvested with a tax benefit. Very clear, stated in public to a congressional committee. And in the same presentation, it was made very clear that Cerro Verde would have to pay royalties with respect to the concentrator plant. You see the language on the screen. The royalties do apply to the concentrator plant. Again, I'm saying it again, it's a public statement before a congressional committee, not a statement whispered by one cigar-smoking gentleman to another in the back room of a bar. In May of 2006, Minem explained again before the Energy and Mines Congressional Committee and the Congressional Working Group that the concentrator project was not covered. The Vice Minister of Mines, Mr. Mucho, also spoke on May 3, 2006, before the Energy and Mines Committee, Congressional Committee and the Congressional Working Group, and made comments that were very similar to the ones you saw earlier by the Minister of Mines and by Mr. Isasi. And Mr. Isasi, again, in answering questions, says very clearly, a contractual agreement, the stability agreement, prior to the royalties law, protects the investment subject matter of the agreement against this new obligation. These agreements do not shield all companies nor all mining concessions. The only thing it does is to provide guarantees to a specific investment project which has been described in a feasibility study and integrated into the agreement. In June 2006, SUNAT prepared a report analyzing the scope of Cerro Verde Stabilization Agreement. And here is what this report says. Since the project to expand Cerro Verde's current operations through a primary sulfide concentrator plant pertains to a completely different investment than the leaching project, as approved for the purposes of entering into an agreement of guarantees, as described in section 1.2 of this report, we can conclude that such an expansion would not be within the scope of the agreement of guarantees since it is a new investment not contemplated by the parties when the agreement was entered into. And this is SUNAT in June of 2006. Claimant appears to question that this report was in fact prepared in 2006, but what we know it was because for two reasons. One, there is a SUNAT report of 2010 regarding the 2008 audit of Cerro Verde, and it refers, as you can see on the screen, in the background section, refers to SUNAT's June 2006 report. And SUNAT 2010 report notes that it is based on SUNAT's June 2006 report. And so, in another SUNAT document, there is a reference to a SUNAT report of June 2006. So we know, one, it was prepared in 2006, two, it was the basis for the subsequent SUNAT report. And then, in addition, the author of that report, Ms. Gabriela Bedoya, has testified in this arbitration that the SUNAT report was indeed prepared in June 2006, and she confirmed that in her direct examination at the Cerro Verde hearing. She confirmed that she prepared the 2006 report in 2006, and she was not cross-examined on that testimony. Now, here is, we come to June 16, 2006. Mr. Isasi, the legal advisor of MINEM, prepares a report for the Minister of Energy and Mines regarding the scope of the 1998 Stabilization Agreement, and he concludes in this report that the concentrator project was not covered. And you see that on the screen, and the language is very clear but consistent with all the previous document that I showed you. And so claimant says, we're shocked we tell you, to learn for the first time, this is a vote-fast of the Peruvian government. Until now, the Peruvian government was consistently saying the stabilization agreement covered the concentrator plant, and now, all of a sudden, this is a sudden change, a vote-fast, a completely different interpretation. Well, in fact, this morning, you heard claimant's counsel referring to this report and this date that, you know, the position of the Peruvian government changed just like that, all of a sudden, June 16, 2006. I showed you many, many documents that expressed in almost the exact same words the same position and the same interpretation predating that June 16, 2006 document. And some of them, at least, were public. So to say that the Peruvian government on June 16, 2006 changed its position just like that is just not tenable. Another document from June 23 to August 2, the Congressional Committee overseeing Proinversión, the Peruvian Investment Promotion Agency, had a series of roundtable discussions with local leaders from Arequipa, MINEM, and MEF officials and representatives of Cerro Verde. At the roundtable discussions, MINEM made another presentation and distributed a copy of that presentation, which was very similar to the one made in May of 2006 before Congress, in which MINEM stated that the Cerro Verde concentrator project was not covered under the 1998 Stabilization Agreement. You see a copy of that presentation. Mining royalties do apply to the Cerro Verde primary sulfide project. It's not part of the leaching project, and for this reason, it does not benefit from the stabilized regime. It's a new project that does not benefit from tax, exchange rate, and administrative stability. In consequence, it will pay royalties when it enters into production. Now, claimant says we participated in roundtable discussions, but we were not informed that the concentrator project would not be covered. We never saw this presentation. Well, let's look at the facts. The minutes of the roundtable discussion confirm that representatives of Cerro Verde, including claimant's local counsel in this arbitration, Mr. Rodrigo, were present at the discussion. You see an excerpt from the meeting minutes that said, for Sociedad Minera Cerro Verde, Jorge Benavento Risco, Deputy Manager of Corporate Affairs, Luis Carlos Rodrigo, Carolina Rios. And then the agenda was income tax, royalty payment, and investment profits. After listening to the intervention on the agenda item, the attendees agreed to the following. So they listened to the presentations and they agreed. We have, nevertheless, they say we weren't there, we didn't know. We have an independent source, an entity that filed an amicus brief, and that was referred to by counsel this morning, that event, an entity that, a third party, an NGO files an amicus brief in another litigation, complaining against SUNAT. And in its brief, this entity, an independent third party, not friendly to SUNAT obviously because it's suing SUNAT, it says, the roundtable, we were provided with an extensive defense referred to in the PowerPoint bound copy attached to the minutes regarding the reinvestment of profits and mining royalties of Cerro Verde. So he says the participants of the in the roundtable were provided with a copy of that presentation. he attaches this. And that is clearly proof that the presentation was made available to all the participants in the roundtable discussion. It was distributed to the attendees. There are many other documents that I can show you. In response to a taxpayer inquiry, Sunat issues a report in September of 2007, and this report says, for the investment activities that are the subject matter of the agreements and that were indicated in the feasibility study, the taxability extends to those and not others. Those are the subject matter of the agreements and indicated in the feasibility study. So let's conclude on that point. All relevant Peruvian authorities, including SUNAT, MINEM, and the MEF, were consistent and transparent in their interpretation of the 1998 stabilization agreement. The Peruvian government has consistently held the position that what is stabilized under a stabilization agreement is a specific investment project, not mining companies, not concessions as a whole, not economic administrative units as a whole, not mining units, whatever that means, as a whole. And the specific investment project covered under a stabilization agreement is the one that is defined in the feasibility study, which is incorporated into the stabilization agreement, and which is the subject matter of the stabilization agreement. And all the documents I showed you demonstrate that the Peruvian government consistently held that position. Now, just one word about the conspiracy theory that claimant advances, that this was under political pressure. What these exchanges between members of Congress and the executive show is that members of Congress, legitimately exercising their role as legislators, exercise their right to question actions of government officials and demand explanations. MINEM officials, however, consistently defended Cerro Verde's leaching project stabilized status. They never caved in on that. They consistently defended that status before Congress. So they resisted that political pressure. But they said what they had consistently said, which is what is stabilized, the leaching project. What is not stabilized, the concentrator project, that pay royalties. Now, you heard a lengthy explanation of Peru's economic difficulties, the need to generate revenue, the pressure to generate revenue from the mining companies. Well, if indeed that were the case, then SUNAT and MINEM would have gone after all mining companies based on this pressure, alleged pressure that essentially required MINEM and SUNAT to change their policies. There would have been no reason to go after one. They would have gone after others, everybody who had stabilized and non-stabilized project, and would have required everybody to pay royalties. That is inconsistent with their own argument, which is that in the case of other companies, and I'll get to that in the case of other companies, Peru did not require the payment of royalties with respect to allegedly non-stabilized projects. So why would Peru, under political pressure to get mining companies to pay royalties, single out Cerro Verde, but let off the hook everybody else, as they seem to argue? All right. So this is now a brief discussion of other mining companies. And so let me, before that, take just 30 seconds to summarize where we are. Under the stabilization agreement, it clearly applies only to the leaching project. The feasibility study clearly applies only to the leaching project. The law says that the stabilization agreement applies to a project-by-project basis, in this case to the leaching project and not to the concentrator plant. the Peruvian courts confirmed that under Peruvian law, this is the way to interpret the 98 stabilization agreement and the law. We showed you that they knew the concentrator project was not covered by the stabilization agreement. We showed you that the Peruvian government consistently interpreted the stabilization agreement as covering the leaching project, but not the concentrator plant. So to overcome that, they submit additional claims which are, in a way, they might be characterized as claims of desperation. And these are the three claims that I'll discuss now. One is, oh, they let others off the hook. Well, very briefly, this is Yanacocha, and you see on the screen we have color there. Yanacocha, there is a concession called Chopiloma Tres, and there were two stabilization agreements relating to this Chopiloma Tres concession. In addition, there is a concession called Chopiloma Dos, and you see that there are two stabilization agreements, 98 and 2003, that cover the Chopiloma Dos concession. So with respect to the same concession, there are two different stabilization agreements. Two stabilization agreements with respect to Chopiloma Dos, two stabilization agreements with respect to Chopiloma Tres. So this shows that the mining stabilization agreements are not granted for the entire concession. If they were granted for the entire concession, there wouldn't be two stabilization agreements for one concession. Then why would Yanacocha sign three different agreements and force at the same time that relate to the same concession? Well, so claimant says, well, but Yanacocha was able to sign two agreements with respect to, say, Chopiloma Tres concession because each agreement was signed with respect to a different economic administrative unit. And those different units happen to share the Chopiloma Tres concession. Well, leaving aside the fact that they did not have an economic administrative unit, the point is this is irrelevant. It's irrelevant that that Chopiloma Tres concession is included two different economic administrative units because under their own theory, one concession, one stabilization agreement, but this is clearly not the case. One concession, two stabilization agreements. Then they say Yanacocha was able to sign two agreements with respect to the Chopiloma Dos concession because each agreement refers to a different mining pit within the Chopiloma Dos concession. Well, maybe, but again, that's irrelevant. Chopiloma Dos concession contains two separate pits, but under claimant's own theory, they wouldn't have been required to sign different agreements with respect to the same concession, because remember their theory. The stabilization agreement covers the whole concession. So the Yanacocha example doesn't help their case. Let's look at southern Peru. Claimant says the southern 1994 stabilization agreement covered the Caljone and Toquepala economic administrative units. Well, claimant's own witness, Hans Fleury, who was then legal director of Southern, understood that Southern's 94 stabilization agreement covered only its leaching project. On July 12, 1994, as you can see on the screen, Southern signed a stabilization agreement for the, quote, leaching Electro 1 project, close quote, located in two administrative economic units, the Caljone and Toquepala economic administrative units. And this stabilization agreement was signed by Mr. Fleury, and you can see it says leaching Electro 1 project. More than that, on August 15, 1994, Southern Peru's president sent a letter to Minem. That letter was also signed, in addition to the president, was signed by Mr. Fleury. And that letter confirmed that Southern Stabilization Agreement applied exclusively to the investment project indicated in the agreement, that is the leaching project. And that Southern, importantly, would keep separate accounts for that specific project. This is Southern's understanding of what was stabilized in their own words. And look at what it says. The contractual guarantees will benefit Southern Peru exclusively for the construction project of the leaching plant. The additional production that will be obtained from the operation of the aforementioned plant and the income it obtains for the exportation and sale of said additional production of cathodes. And then Southern will keep separate accounting and will reflect in separate results the operation of the sales for the other products resulting from its mining activity. Southern, the example they give you, understood very well that what was stabilized was the leaching project and no other project, and said to Minem, and we will keep separate accounts. And in Minem's presentation to the Congressional Energy and Mine Committee, it showed that Southern actually paid royalties with respect to their primary sulfide project, which was not stabilized, even though that primary sulfide project, concentrator project, was also within the Cuajone and Tuquepala economic administrative units. And so if Clayman's theory regarding the scope of stabilization agreements were correct, then Southern would not have paid royalties on a project within the same economic administrative units as the stabilized project. But they did. So you see Southern Peru's understanding. At the time, their witness was the legal director. You see what they understood to be stabilized and what they understood not to be stabilized. Tintaya. Contrary to what Claimant says, SUNAT has held with respect to other companies that stabilization agreements apply exclusively to the investment described in the corresponding feasibility study. So let's look at one of SUNAT's resolutions related to the assessment of Tintaya. After analyzing the mining law and the mining regulations, SUNAT stated that the mining stabilization agreements only cover the specific investment defined in the corresponding feasibility study. And SUNAT explained that the same taxpayer can be subject to different tax regimes, one with respect to a stabilized investment and one with respect to a non-stabilized investment. And this, SUNAT said, was also the case of Tintaya. So this is the treatment of Tintaya. And it defeats their point. So contrary to Claimant's allegation, they have attempted to introduce alleged disparate treatment as between SUNAT's treatment of Cerro Verde versus the treatment of other mining companies, but we just show you documents, SUNAT resolutions regarding Yanacocha, Southern Tintaya. They demonstrate that no such differential treatment occurred. But in any case, Claimant has not raised a discrimination claim as they admitted in the March 29 letter. Even if they did, Claimant has failed to show that the circumstances relating to the other mining companies are comparable to Cerro Verde. I mean, to show discrimination, they have to show like circumstances. Claimant has not shown that any of the other mining companies developed an entirely new investment project completely unrelated to the stabilized project, e.g. project aimed to produce a separate product through a different process entirely unrelated to the product produced through the stabilized project, within the same concession in which it developed the stabilized project, and that SUNAT treated that new investment project as a stabilized project. And as I told you, all this discussion about application to economic administrative units, they don't have an economic administrative unit. And in any case, they should not be permitted to raise now a discrimination claim. Well, before I leave this topic, Claimant made a big case, a big argument about SUNAT's assessment on Milpo, another mining company, and you heard this morning an extensive discussion. But in reality, the documents that Claimant discussed do not support Claimant's interpretation that stabilized guarantees are applied to entire concessions or mining units. And I'll briefly tell you why. Just to provide some context, Milpo signed in 2002 two separate stabilization agreements for two different mining projects, the Cerro Lindo project and the Porvenir mine project. Unlike Cerro Verde's mining projects, Cerro Lindo and El Porvenir, one, were geographically located apart from each other, and two, were constituted as different economic administrative units, which, again, to recall, to constitute an administrative economic unit, there is a formal procedure. You apply and you get an approval. It must be officially approved. So because they had two different geographic areas, not adjacent, and because they had two different approved economic administrative units, they are not in like circumstances with Cerro Verde, which has one geographic area that we're talking about and has no economic administrative unit. The assessment that were added to the record, SUNAT's assessment, that were discussed extensively this morning by counsel for claimant, also do not help claimant's case, because in those cases SUNAT did not analyze the scope of the stabilization agreements. SUNAT focused on auditing very specific findings, such as the expenses presented by MILPO as tax deductions and the classification of certain assets for depreciation purposes, among others. SUNAT did not analyze whether the investments were stabilized or not. And so, for those two reasons, claimant cannot assert that SUNAT interpreted stabilization agreements differently in the case of MILPO from the case of Cerro Verde. Now, the tax tribunal claim, which I will discuss very briefly, because the evidence is there for Peru and not there for claimant. Claimant asserts that President Olano, the president of the tax tribunal, appointed Ms. Villanueva to assist Chamber 1 in order to quote-unquote manipulate the decision on the 2008 royalty case. Wrong. Contrary to those assertions, President Olano appointed Ms. Villanueva, a qualified and experienced law clerk, asesora in Spanish, due to staffing shortages. Claimant asserts that President Olano dictated how Ms. Villanueva should consider the 2008 royalty case. Wrong. Contrary to those assertions, Ms. Villanueva read the 2008 royalty case file and gave it an independent consideration. Claimant asserts that President Olano interfered with the resolution process in the assessment cases that I'm not going to go through that are on the screen. Again, wrong. The vocales in the respective chambers independently considered and decided the royalty cases before them. Claimant asserts that President Olano fast-tracked the resolution of the 2008 assessment so that royalty cases would be decided in the same way. Again, wrong. The vocales in the respective chambers determined their own timing regarding the issuance of those decisions. Claimant asserts that Mr. Mejia Nonacondor should have been disqualified from the 2010-2011 royalty case, alleging that he previously worked at SUNAT, the SUNAT department that initially confirmed that royalty assessment. Wrong again. He had previously worked at SUNAT but did not work on the 2010-2011 royalty case. Claimant says that the plenary chamber did not deliberate on Cerro Verde's request for disqualification, and President Olano, as the vocal ponente of the plenary chamber, drafted the plenary chamber's resolution rejecting Cerro Verde's disqualification request. Wrong again. The plenary chamber carefully considered the request for disqualification and denied it because it was meritless. They say Ms. Villanueva improperly acted as the vocal in the Q4 2011 royalty case. Wrong. Cerro Verde did not even try to disqualify Ms. Villanueva from the fourth quarter 2011 royalty case. I'm doing this in the summary fashion because the evidence is in the record and you have witnesses. But it's important to emphasize one point. Claimant asserts that the Peruvian government as a whole, including the tax tribunal, acted under political pressure by committing a vote-face against Cerro Verde. Now, claimant's own witness, Mr. Estrada, who has no first-hand knowledge of the royalty cases against Cerro Verde because he was not a vocal in the chamber deciding those cases, the chambers deciding those cases. But even he, the whistleblower as it were, does not testify about political pressure in his witness statement. Instead, he asserts that President Olano acted against Cerro Verde in the royalty cases in order to increase the performance bonuses to herself and the vocales. And you see the excerpt from his witness statement on the screen. This claim is not only unsupported by any evidence, but it's nonsensical, because under this theory, the tax tribunal would essentially be squeezing money from all taxpayers appearing before the tax tribunal, not just Cerro Verde, to increase their bonuses. And so the claim that the tax tribunal acted inappropriately across the board is baseless. In fact, Mr. Estrada admits that those bonuses were never paid. But he doesn't even assert that there was any outside political pressure. Now, to complete the discussion of the tax tribunal, I think it's important to note that claimant never complained about those alleged due process violations at the time. Now, they say in this arbitration they did not know the full extent. They cannot say they didn't know about anything, but they didn't know about, quote unquote, the full extent of those due process violations until 2021, when this arbitration began and they received documents in document production. But claimant's dispute regarding the scope of the stabilization agreement was nevertheless submitted to the Peruvian courts, including the Supreme Court. The Peruvian courts, as we saw, analyzed the terms of the 1998 stabilization agreement and concluded twice that the stabilization agreement did not cover the concentrator project. Claimant did not complain about due process violations in the Peruvian courts. They had their day in court, Cerro Verde did, does not complain about due process violations in courts. What does that mean? The invention in this arbitration of a claim of due process violation by the tax tribunal is futile. Even if, which we deny, there was a due process violation on the level of the tax tribunal, this would not change the substantive correctness of the tax tribunal's decision that the stabilization agreement did not extend to the concentrator plant, because that decision was confirmed all the way through by the Peruvian judiciary. So the substantive result is the same. And even if, which should not be the case, you find some due process violation by the tax tribunal, they have to prove that those due process violations caused them harm, and they didn't, because the Peruvian judiciary, without any alleged due process violations, reached the same substantive result. Very briefly, the claimant's allegations that the Peruvian government somehow misled Cerro Verde into participating in the voluntary contribution programs are wholly unsupported. There is no evidence of any quid pro quo, no evidence that Cerro Verde's that the Peruvian government ever represented to Cerro Verde that the concentrator project would be exempt from royalties if they participate in these voluntary contribution programs. In fact, at the time when Cerro Verde agreed to make voluntary contributions in 2006 at the roundtable we discussed, Cerro Verde, as I showed you, already knew that the concentrator project was not covered. I told you about all the we showed you all the documents where Cerro Verde knew the concentrator plant was not covered. I showed you the presentation at that very same roundtable discussion. You have it again. They say, oh, we didn't know. Not only we didn't know, but they want to represent to you that there was some sort of a quid pro quo, a promise. You're not going to pay royalties if you participate in the voluntary agreements. Well, to begin with, there is a minor, I say minor in quotation mark, discrepancy in their argument. If, as they say, the concentrator project was covered by the stabilization agreement from the beginning, why would there be any quid pro quo, any promise that, don't worry, you are covered if you participate? Well, whether they participate or not in the voluntary programs, if they are right, they're covered. The concentrator plant is covered. So this quid pro quo makes no sense. But look at the agreements that they signed. Those are the three agreements we're talking about. And I showed you all the documents that before that they knew very well how the Peruvian government interpreted the 1998 stabilization agreement. But more importantly, and what makes that claim a claim of desperation, we are showing you one provision from one of those agreements, the voluntary contribution agreement. And this is what it says, and it says just the opposite, the agreement that they signed. this agreement does not replace the obligations corresponding to the different government levels, being these national, regional, or local, in terms of the distribution and investment of the resources from the mining canon and the mining royalty, which shall be subject to the applicable regulations. Not only there is no quid pro quo, but this agreement has a specific provision that states explicitly that if you have to pay royalties, you pay royalties. This agreement does not replace the existing obligation to pay royalties. So to say that we signed this agreement in exchange for a promise that we wouldn't pay royalties, well, the agreement says the exact opposite. Now, I will stop here and hand the floor to my colleague Jennifer Howard-McCandless to talk about jurisdiction, merits, and damages, and I thank the members of the tribunal.
Thank you, Mr. Alexandrov. Madam President and the members of the tribunal, I'm going to discuss three topics: jurisdiction, merits, and briefly damages. So claimants' claims fall outside the tribunal's jurisdiction based on 5 grounds, and you see those on the screen in front of you. Claimants' claims are outside the 3-year statute of limitations period provided under Article 10.18.1 of the TPA. Claimants' claims based on penalties and interest related to Senat's tax assessments constitute taxation measures, which are excluded from the scope of the TPA pursuant to Article 22.3.1. Claimants' claims are based on acts or facts that occurred before the TPA entered into force, and thus they're outside the scope of the TPA under Article 10.18.4 of the TPA. And claimant failed to prove that it relied on the 1998 stabilization agreement when it established or acquired its covered investments as required under Article 10.16.1 of the TPA. The first ground. Claimant's claims fall outside the limitations period provided under Article 10.18.1 of the TPA, and you see that provision on the screen in front of you. The TPA prohibits the submission of claims to arbitration if more than 3 years have passed from the date on which the claimant first knew or should have known of the alleged breaches, and that it or its enterprise that it's arguing on its behalf incurred loss or damage. That's the Corona Materials Award discusses that well. It talks about the earliest possible date. Thus, if the tribunal finds that claimant first knew or should have known of the alleged breaches and loss of damages more than 3 years before claimant filed its notice of arbitration, then claimant's claims would be time barred. Now, claimant makes 2 categories of claims: one for alleged breaches of the stabilization agreement on behalf of SMCV, and 2 alleged breaches of the TPA on its own behalf. First, with respect to the alleged breaches of the stabilization agreement. Claimant first knew or should have known of the alleged breaches and that SMCB incurred loss or damage as early as August of 2009. That was when Senat notified SMCB that it assessed royalties on SMCB's concentrator project for the 2006-2007 period, because the project was not within the scope of the stabilization agreement. Now, claimant filed its notice of arbitration in February of 2020, and therefore the 3-year limitations period cutoff date is February 2017. And clearly the date of 2009 is much earlier than the 2017 cutoff period. Senat also notified SMCB of the extent and the amount of the royalties owed by SMCB with penalties and interest, as you can see on the excerpt on the screen. Thus, as of that date, August 2009, claimant and SMCB knew of the alleged breaches and of the loss or damage. Now, at a minimum, claimant first knew or should have known of the alleged breaches and that SMCB incurred loss or damage no later than September of 2009. That was when SMCB challenged the 2006-2007 royalty assessment before Senat. So therefore, recognizing that it acknowledges that there was a wrong that was harmed against them. And you see that claim on the screen in front of you. Now, claimant says that it knew of the alleged breaches and loss or damage after the cutoff date. What are the reasons? They say the alleged breaches occurred each and every time that Senat's royalty and tax assessments became binding and enforceable against SMCB. that for each of those times, Peru committed a separate breach of the stabilization agreement, and that SMCB incurred loss or damage only when those assessments became binding and enforceable. Well, claimant's assertions are meritless. Why? Claimant first acquired the knowledge of the alleged breaches when it was notified by Senat of the assessment in August of 2009, or at minimum, when they themselves challenged that, recognizing there was something with which they were disagreeing with respect to the interpretation of the stabilization agreement. And that was in September of 2009. And you see on the screen, Apatek's award is looking at any challenge that the FDA in that case decision itself had to be brought within 3 years and could not be delayed by resort to court actions. And the U.S. in its non-disputing party submission agrees, and you see the provision on the screen in front of you in paragraph 9. Senat's royalty and tax assessments on SMCV's concentrator project, the challenge measures, do not give rise to separate breaches, and the limitations period does not renew each and every time that the challenge measure occurs, because Senat's assessments are part of a series of similar or related actions by the respondent state. And the U.S. in its non-disputing party submission agrees, and you can see those provisions on the board in front of you, on the screen in front of you, and that's in paragraphs 9 and 10 of their non-disputing party submission. And the Corona materials is the location where that language comes, a series of similar and related actions by a respondent state. An investor cannot evade the limitations period by bringing its claim on the most recent transgression in that series, which is exactly what claimant is trying to do here. Thus, claimant's knowledge of alleged breaches based on Senat's assessments must be traced to the first assessment in the series of Senat's assessments. In this case, is the 2006 to 2007 royalty assessment. Now, claimant knew that SMCV incurred loss or damage as a result of the assessments when SMC was first notified in August of 2009, or at the least when SMCB first challenged that assessment in September of 2009. And you see that the U.S. in its non-disputing party submission agrees. That's in paragraph 11 of their submission. And the Grand River decision on jurisdiction is in accord. When liability accrues, it's before he or she actually dispenses any funds, even if there is no immediate outlay of funds or of the obligations. So it's once you have knowledge of that loss, not necessarily when the obligations are being paid. Now, those are with respect to the royalty assessments. And if the tribunal, that we say because the interpretation of the stability agreement is the same with respect to royalty assessments and tax assessments, that's the earliest point in time in which the claimant knew or should have known of the alleged breach and of the alleged loss. But if the tribunal is going to assess them separately, the royalty and the tax assessment occurred. First tax assessment claimant first knew about the alleged tax assessment in December of 2009, and then they challenged that in January of 2010. Those dates, as the previous dates, though, are well before, years before the cutoff date of February 2017. And the key dates we just discussed are summarized on that table in front of you. Now, SMCV continued to be notified of many of Senat's assessments, and they continued to challenge them well before the February 2017 cutoff date. And we, in our respondents' rejoinder submission in Table 3, show a list of those dates. Alleged breaches of the TPA. So claimant claims alleged frustration of legitimate expectations, arbitrary actions, and inconsistent and non-transparent acts, and they say they fall outside, and those fall outside the TPA's limitations period. These claims are all based on Senat's royalty assessments against SMCB, and you see the different claims there in front of you. And therefore, that knowledge, claimant's knowledge of the alleged breaches and the incurred loss or damage fall within the same dates of the royalty assessment that I discussed earlier. August 2009, initially when the SMCB was first notified of the assessment, or at minimum September of 2009 when SMCB first challenged that assessment. With respect to the due process, claimant's due process claims, they claim violations related to the tax tribunal's proceedings in the 2006, 2007, and 2008 royalty assessments. Those also fall outside the TPA's limitations period. Claimant first knew or should have known of the alleged breaches and the loss or damages when SMCV was first notified of the tax tribunal decisions regarding those assessments, and that occurred in June of 2013, again, years before the February 2017 cutoff date. Claimants' claims based on Senat's refusal to waive penalties and interest on the royalty and tax assessments also are outside the tribunal's jurisdiction. Claims related to royalty assessments, claimant first knew or should have known of the alleged breaches of the loss or damage on April 22, 2010, when SMCV was notified that Senat denied its request to waive penalties and interest related to 2006-2017 royalty assessment, again, years before the 2017 cutoff date. Claims related to tax assessments, those claims are barred under Article 22.3.1 of the TPA, which excludes from the TPA claims based on taxation measures, which we'll discuss shortly. In sum, with respect to the first ground, claimant filed its notice of arbitration in February of 2020. The cutoff date under Article 10.18.1 of the TPA is February 2017. Claimant first knew or should have known of the alleged breaches and that SMCV incurred loss or damage many years before the cutoff date. Thus, claimant's claims of alleged breaches of the 1998 Stabilization Agreement and almost all of claimant's claims of alleged breaches under the TPA fall outside the tribunal's jurisdiction. The second ground. Claimant's claims of alleged breaches of the TPA based on penalties and interest related to tax assessments fall outside the scope of the TPA pursuant to Article 22.3.1 because those measures constitute taxation measures. You see the article of the TPA in front of you on the screen. The TPA excludes taxation measures from the scope of its protection. In its reply, claimant agrees that the claims related to breaches of TPA based on tax assessments are barred under Article 22.3.1 because, as claimant acknowledges, tax assessments are tax measures. However, claimant argues that the penalties and interest which were imposed on the assessed tax amounts in the same tax assessments are not taxation measures, and thus, according to claimant, its claims relating to the penalties and interest are not barred by Article 22.3.1. Well, claimant's arguments are without merit. The TPA defines measures broadly to include any law, regulation, procedure, requirement, or practice. And you see the language on the screen in front of you. Well, the enforcement of a tax is, of course, a practice. Thus, claimant's attempt to limit taxation measures to merely taxes must fail. In conclusion, with respect to the second ground, Senat's imposition and maintenance of penalties and interest on taxes assessed in the tax assessments against SMCV constitute taxation measures under Article 22.3.1 of the TPA, because those measures are taxation practices aimed at enforcing tax obligations. Thus, all of claimant's claims of alleged breaches of the TPA based on Senat's imposition and maintenance of penalties and interest applied to Senat's taxation assessments against SMCV are barred under Article 22.3.1 of the TPA. The third ground. Claimant's claims fall outside the scope of the TPA under Article 10.1.3 because claimant's claims are based on acts or facts that occurred before the TPA entered into force. And you see the provision of the TPA in front of you on the screen. The TPA entered into force on February 1st, 2009. Claimant's claims related to the royalty and tax assessments are all based on or are deeply and inseparably rooted in acts or facts that occurred before the TPA entered into force, and thus claimant's claims based on those measures fall outside the tribunal's jurisdiction. Claimant alleges breach of the 1998 Stabilization Agreement and Article 10.5 of the TPA based on Senat's assessments. By claimant's own telling, the cause of and the basis of all of Senat's assessments on SMCV's concentrator project is MNEM's interpretation of the scope of the 1998 Stabilization Agreement and the mining law and regulations contained in MNEM's June 2006 report. And you heard earlier today in their presentation, they describe it as this. Claimant reiterated that in its opening statement that the novel interpretation and the interpretation that was, quote, drafted behind closed doors, close quote, were based on Mr. Asasi's June 2006 report. Well, that report was, of course, many years before the TPA entered into force. And you see on the screen in front of you that that claimant is saying that Menem's June 2006 report directly caused Sanat to assess royalties and taxes on SMCB's concentrator project. And you see the quotes on the screen from claimant's memorial and from their memorial. So you see those on the screen. Claimant also asserts that Menem's June 2006 report is the basis of all of Sanat's assessments on SMCB's concentrator project. And you see the quotes in which that appears in their submissions. That is from claimant's memorial and also from claimant's notice of arbitration. And claimant also stated earlier today in their opening statement that the 2006 Sanat report, that it was Sanat, quote, Sanat's position was already decided in 2006. So they're admitting all of these acts and facts occurred, and they were the basis of the Sanat's assessments, and all of these are well before the TPA entered into force. Indeed, with respect to Sanat's audit, they had an audit in 2008, and claimant today said the audit culminated, in quotes, in Sanat's 2006 and 2007 royalty assessment. So clearly, these are acts that occurred and were the basis of the assessments on which claimant roots their claim, and all of these are occurring before 2009, before the TPA entered into force. So in sum, with respect to this ground, claimant asserts that the genesis of the entire dispute is Menem's interpretation of the scope of the stabilization agreement and the mining law and regulations that are reflected in the June 2006 report. Claimant's claims are also based on Sanat's assessments of sales from SMCB's concentrator plant, which began with Sanat's assessment of the same notified to SMCB in June of 2008. The TPA entered into force on February 1st, 2009. Thus, claimant's claims based on Sanat's assessments are deeply and inseparably rooted in an act or fact that took place before the date of entry into force of the TPA and therefore fall outside the tribunal's jurisdiction. The fourth ground. Claimant's claims of alleged breaches of the 1998 stabilization agreement cannot be submitted to international arbitration pursuant to Article 10.18.4 of the TPA because they have already been submitted to dispute settlement procedures in Peru, and you see the provision on the screen in front of you. Accordingly, for claims of breach of an investment agreement submitted by the claimant on behalf of an enterprise that it owns or controls, Article 10.18.4a bars the submission of those claims to international arbitration if they were previously submitted to an administrative tribunal of the respondent, or a court of the respondent, or any other binding dispute settlement procedure. Well, all three are satisfied here. Administrative tribunal. SMCB challenged almost all of Sanat's assessments on its concentrator project before Sanat's Claims Division and the Tax Tribunal, both of which are administrative tribunals. And indeed, claimant admitted that the Sanat's Claims Division and the Tax Tribunal are administrative tribunals in Peru. That's at claimant's reply at paragraph 259. And indeed, earlier today, claimant also made a comment that the first instance decision maker in the administrative process is Sanat's Claims Division, and also that at the last instance decision maker in the administrative process is the tax tribunal, was supposed to set things straight. So the claimant is still admitting today that Sanat's Claims Division and the tax tribunal are administrative tribunals in Peru. Courts of Peru. SMCB also submitted claims of the same alleged breaches of the stabilization agreement to the courts of Peru. And you can see each of their submissions on the screen in front of you. And the language is very clear. They are stating things such as, those administrative decisions have violated the legal framework applicable to stability agreements for the mining industry and the clauses of the agreement for the promotion and guarantee of the investments that Cerro Verde entered into with the Peruvian state on February 13th, 1998. They submitted those claims before the courts in Peru. Binding dispute settlement procedures. The decisions by SUNAT's Claims Division and the Tax Tribunal are binding on the taxpayer appearing before them unless they're successfully appealed. Claimant and its Peruvian law expert, Dr. Bullard, admit that a decision of SUNAT's Claims Division is final and binding if it's not appealed to the Tax Tribunal by the applicable deadline, and that the decision of the Tax Tribunal is final and binding after it is issued and notified to SMCV. SMCV's claims before SUNAT's Claims Division, the Tax Tribunal, and Peruvian courts, and SMCV's claims in this arbitration are for the same alleged breaches of the stabilization agreement. And they also share the same fundamental basis, because resolving the arbitration claims requires this tribunal to reach and resolve the same dispute underlying the claims previously submitted to Peruvian fora. The SMCV complains about the same government measure. SMCV claims the same legal rights under the same legal instrument. SMCV's claims raise the same legal question regarding the same investment project, and SMCV's claims are governed by the same legal framework. The similarities between SMCV's claims before the Peruvia fora and its claims submitted in this arbitration are undeniable and are shown in Table 4 of Respondent's Rejoinder. Importantly, the Peruvia fora have already resolved repeatedly the same dispute underlying SMCV's arbitration claims, whether the 1998 stabilization agreement covered SMCV's concentrator project, and it found that the stabilization agreement did not cover SMCV's concentrator project. And you see in the table below and in the next slide, which are reproduced from Respondent's counter-memorial at Table 4, it shows that each time SUNAT's Claims Division and the Tax Tribunal resolved the dispute and determined that the stabilization agreement did not cover the concentrator project. In sum, with respect to Ground 4, the record is clear that SMCV has submitted the exact same dispute underlying its arbitration claims, whether the 1998 stabilization agreement covered SMCV's concentrator project to SUNAT's Claims Division, the Tax Tribunal, and Peruvian courts. SMCV has submitted the exact same dispute to administrative tribunals, courts of the respondent, and binding dispute settlement procedures. Allowing SMCV's arbitration claims to proceed would, in effect, allow claimant and SMCV to take a second, or a third, or even a fourth bite of the same apple, contrary to the text and purpose of Article 10.18.4 of the TPA. And the fifth ground, claimant failed to prove that it relied on the 1998 stabilization agreement when it established or acquired its covered investments, and thus it may not submit claims for breach of an investment agreement pursuant to Article 10.16.1 of the TPA. You see the provision on the left. For a claimant to submit a claim of breach of an investment agreement on behalf of an enterprise that it owns or controls under the TPA, two requirements must be met. We'll focus on the second requirement. The claimant must have relied on the investment agreement when it established or acquired its covered investments. For an agreement to be considered an investment agreement within the meaning of the TPA, a claimant must have relied on the agreement when it established or acquired its covered investments. This is the definition provided on the screen in front of you. Claimant did not rely on the 1998 stabilization agreement when it acquired its covered investment in SMCV or in the so-called Cerro Verde production unit or in the mining and beneficiation concession. The stabilization agreement is not, therefore, an investment agreement within the meaning of the TPA. Now, contrary to claimant's assertions, there is no question that the TPA requires the claimant's reliance for it to be entitled to submit a claim for a breach of that agreement, whether it's on its own behalf or whether it's on its own or on the enterprise's behalf. Article 10.16 of the TPA sets the conditions under which a claimant, in this case Freeport, must submit a claim for arbitration. Not its covered investment, on whose behalf it is asserting, in this case SMCV, and nor its predecessor, in this case Phelps Dodge. it's claimant's burden to prove its reliance on the investment agreement when it established or acquired its covered investments. And the U.S. appears to agree in its non-disputing party submission in paragraph 6. Claimant itself understood that Article 10.16.1 of the TPA requires its own reliance on the 1998 Stabilization Agreement for it to be entitled to submit a claim for breach of an investment agreement under the TPA. Claimant asserted in its written submissions that it relied on the Stabilization Agreement, and those are quotes on the screen in front of you, in its notice of arbitration and its memorial. Now, claimant would not have asserted that its own reliance on the Stability Agreement repeatedly if it too did not interpret Article 10.16.1 as requiring claimant's reliance on the purported investment agreement when it acquired its covered investments in order to bring claim for breach of the agreement under the TPA. Claimant, however, has failed to prove that it relied on the Stabilization Agreement when it acquired its covered investments on March 19, 2007. Matter of fact, claimant did not and could not produce a single piece of evidence. Instead, claimant, because it can't prove it, it now argues that it is sufficient for other entities, SMCV, its covered investment, or Phelps Dodge, its predecessor, and saying that they relied on the Stabilization Agreement in order to satisfy the reliance component. But that does not help claimant's case. SMCV was not and could not be a covered investment under the TPA, whether a Phelps Dodge or a Freeport, because the TPA was not in force when it established or acquired its investment. Just for a second, I'll go back to the definition. This is what claimant is relying on. They're saying, look, it says there's an agreement between the national authority and a covered investment, in this case SMCV, on which the covered investment, SMCV, relied when it acquired or its covered investment, in this case the concentrator. But at that moment in time, when it acquired the concentrator, when it first started to invest in it, was October 2004. It can't be a covered investment at that moment in time because the TPA wasn't in force until 2009. Also, with respect to SMCV's purported reliance on the Stabilization Agreement in order to make its investment in the concentrator itself can't be a covered investment under the TPA because when the investment was made, it was October in 2004 before the TPA entered into force. Same with respect to Phelps Dodge. And some with respect to the fifth basis, Article 10.16.1 of the TPA must be read to require Freeport's reliance on the investment agreement when it acquired its covered investments in March of 2007 for it to be entitled to submit a claim for breach of an investment agreement under the TPA. Claimant has not provided a single piece of evidence to show such reliance. With respect to the merits, claimant alleges that Peru breached the 1998 Stabilization Agreement by imposing royalty and tax assessments on SMCV's concentrator project. Claimant alleges that Peru did not, I know I have like 4 minutes left, right? Or 3 perhaps. Peru did not breach the 1998 Stabilization Agreement. The 1998 Stabilization Agreement does not extend stability guarantees to SMCV's concentrator project. This was confirmed by the Peruvian courts, including Peru's highest court, the Supreme Court. Under the collateral estoppel doctrine, claimant cannot relitigate the same questions that has already been decided. Even if claimant were allowed to submit its claims before this tribunal, the tribunal must apply Peruvian law and reach the same conclusions as it did in the Peruvian courts. Claimant alleges that Peru breached the FET obligations under Article 10.5 of the TPA by frustrating claimant's alleged legitimate expectations, by acting arbitrarily, by failing to act consistently and transparently, and by committing certain due process violations. Well, they allege violations of protections that are not provided under the TPA. They are not the customary international law minimum standard of treatment applicable to the FTA. Obligations under 10.5 does not protect investors against frustration of legitimate expectations, arbitrary actions, or inconsistent and non-transparent actions. And you can see the requirements for proving that on the screen in front of you. They must prove that there has been widespread state practice and opinion juris in order to show that there's that burden has crystallized into rule of customary international law, and they have not been able to prove that. And the U.S. Agrees in its a non-disputing party submission, and you see the relevant provisions on the screen. The only one that has crystallized is with respect to the denial of justice, which claimant does not assert. Then quickly moving to damages, there are 5 bases that respondent states claimant's damages claims also suffer from specific errors. Claimant claims damages that SMCB failed to mitigate. Claimant has improperly included penalties and interest related to tax assessments in Article 10.5 claims. Claimant claims damages for amounts that SMCB never paid. Claimant assumes without support that but for Sunat's assessments, SMCB would have distributed 100% of assessment amounts as dividends at the next actual distribution date, and claimant improperly uses SMCB's cost of equity as its pre-award interest. And there is a discussion on each of these slides, which I won't go into, but of course we have our damages experts who will be here to testify on those issues later on at the end of this proceeding. And therefore, for the reasons, in conclusion, for the reasons stated in respondent's opening and in its written statements, the tribunal lacks jurisdiction to hear claimant's claims, and even if it did have jurisdiction, claimant's claims fail on their merits. And even if the tribunal were to find that respondent were liable, which it should not, claimant's damages claims are inflated. This concludes respondent's opening statement.
Thank you very much, and thank you to both parties for staying within their time limits. And this is highly appreciated. The tribunal may have questions also to counsel, which I indicated already this morning, but we discussed that we do not want to ask these questions now. We have a couple of days in front of us, and we'll have other opportunity to ask questions. So from our perspective, this would bring us to the end of day 1 of our hearing. It was a long day for everyone, but is there anything that the parties wish to address now before we leave?
Nothing on behalf of claimant. Thank you very much.
Thank you. On respondent side?
Nothing on behalf of respondent. Thank you.
Thank you so much. To my co-arbitrators, anything to add, Marisa? No? Thank you. Then we thank you very much for this first day and see us tomorrow at 9:30.